Good morning, everybody. Happy Super Friday. We don't do regular Fridays around here. We do Super Fridays. Welcome to the Courtroom Files Live. It is a bit of a slow start out there in Courtland, but as ever, Miami-Dade never rests. So let's start with Judge Glazer.
All right.
So we're going to try and get you out as quick as possible once your Miami case is closed. Have a good day. Alden Backus is next. He is not. Is he on a TGK?
Yes.
He has locals. What's up with the locals? Where is he?
I have October 7th.
Right, but where is he?
No, he refused.
Oh, he refused. Fine. Locals reset October 8th to see what's going on with the local case. Next we have is James Tanner Quash, Luis Rodriguez. He needs a Spanish interpreter. If he's here, I don't see him.
He refused, Donna.
He refused court. The local case is set January 22nd of 2026. We're going to reset his case here, January 23rd, 2026. Next is Damian Palazzo.
He also refused.
He has locals pending. The next court date is October 23rd, reset October 24th. That's it for warrants. That was not an easy calendar. Thank you, Miss John. Have a good day, good weekend. See you next week, I hope.
Same to you, Judge. Bye.
Now the in-state calendar. Bear with me. I got a few on here. Liz Martinez. Good morning, Miss Martinez. Do you speak English?
Good morning. Yes, I do.
Good morning, ma'am. All right, you were arrested on a warrant. It is from Broward County. The warrant was issued on September 2nd of 2025. You missed court for grand theft charge. I will appoint the public defender's office to represent you on the warrant. Unfortunately, there is no bond. You will have to wait up to 15 days for Broward County to pick you up. The reset date is October 20th to make sure you are transported there. They usually come once a week. Hopefully you'll go sometime next week, okay?
Okay, thank
Have a
you.
nice day. Thank you. Next case we have is Jennifer Middleton. Good morning, Miss Middleton. You have an arrest warrant from Broward County. It was issued on September 18th of 2025. The charge says felony violation of probation.
Yes,
I will appoint the public defender's office for you. Unfortunately, there is no bond on the warrant, and you will have to wait up to 15 days for Broward County to pick you up. Your case is reset here October 20th to make sure you are transported there. And Broward County usually comes once a week. You'll probably go sometime next week.
yes, ma'am.
Have a nice day.
Thank you.
Next case is Roberto Aldana. Good morning.
Yes.
Spanish? Good morning, sir. Are you Mr. Aldana?
Sí. Yeah.
Sir, good morning. You have an arrest warrant from Flagler County, Florida. The
Yes.
warrant was issued October 2nd of 2025.
Yeah.
Señor, usted tiene una orden de arresto de Flagler, Florida. La orden de arresto tiene fecha de octubre 2 del 2025.
Sí.
Yes.
Okay. 1 second. The charge is for violation of probation.
El cargo es por el incumplimiento de la libertad vigilada.
Sí.
Yes.
So I will appoint the public defender's office to represent you on this warrant, and unfortunately, there's no bond on the warrant.
Le voy a asignar la oficina de la Defensoría Pública para que le represente a usted para esta orden de arresto y desafortunadamente no hay fianza en esta orden de arresto.
You're going to have to wait up to 15 days for Flagler County to come pick you up.
Usted va a tener que esperar hasta 15 días para que del condado Flagler lo vengan a recoger.
So the reset date is October 20th to make sure you get transported to Flagler County. If you have any questions, please call the public defender's office.
Así que la fecha para reagendar la audiencia es el 20 de octubre para asegurarnos de que lo hayan venido a recoger de Flagler County. Si usted tiene alguna pregunta, por favor comuníquese con la oficina de la Defensoría Pública.
Have a nice day.
Que tenga buen día.
Next case we have is Daniel Reed.
Michael, thank you for gifting a membership. Very much appreciate that. Jude Curio as Thunder Snow. Welcome, here now a member.
Captain Jack says it's been slow.
Good morning, Mr. Reed. You were arrested on a warrant from Orange County. The warrant was issued May 5th of 2020. The charge is grand theft of property over $20,000. I will appoint the public defender's office for you. Your bond is $3,500. So if you're able to post the $3,500 bond, please do so at the jail you're located at. If you don't have any money for a bond, you'll have to wait up to 15 days for Orange County to pick you up. Your case is reset here October 20th to make sure you either posted a bond or were transported to Orange County. Have a good day.
So I'll post.
Thank you. Next, we have Tavare Whitaker. Do you have the calendar? Is your case on there? Then tell us.
Barbara gives 5 memberships. Thank you, Barbara. Very much appreciate that. Thank you so much.
Whitaker, you have an arrest warrant from Broward County. It was issued August 14th of 2025 for violation of probation. So, it looks like you have 2 cases for violation of probation from Broward. I will appoint the public defender's office for you. Unfortunately, there is no bond. You will have to wait up to 15 days for Broward County to pick you up. The reset date is October 20th to make sure you're transported there. They usually come once a week and you'll probably go sometime next week. Have a nice,
What if they'll
We
pick
only
me
have
up?
then I'll reset again and give them more time, but they're gonna get you. Like the sun rises every day and sets, they're gonna come get you. Okay, don't worry. Have a nice day. Next is John Orbetta. Good morning, sir. You have an arrest warrant from Broward County. It was issued September 11th of 2025. The charge is criminal use of personal identification. And then it says another count, criminal use of personal identification and grand theft in violation of probation. I will appoint the public defender's office for you. There's no bond on the violation of probation charge. So you're going to have to wait up to 15 days for Broward County to pick you up. The reset date here is October 20th to make sure you are transported there. And they usually come once a week. You'll probably go next week.
He also has a 72-hour hold from Florida Corrections.
You also have a 72-hour hold from Florida Department of Corrections as well. Have a nice day.
All right.
All right, next is Teron Davis. We have a big calendar. All right, where's Mr. Davis? Good morning, Mr. Davis. You have an arrest warrant from Broward County. It was issued December 24th of 2024, not in custody capias for felony battery by strangulation and battery, 2 counts of battery. I will appoint the public defender's office for you. You may be entitled to a bond. I don't know, do you have any money to post one if your lawyer's able to get you one?
Yeah.
I'm gonna reset your case in the afternoon, and Mr. Wilson will reach out to Broward County and see if they'll agree to a bond. All right? So he's reset for the PM. Next, we have Marcus Hammett.
Bailey gifts 5 memberships. Thank you, Bailey. Very much appreciate it.
I guess the people on Zoom, the end of the calendar. I don't know. Hi, Mr. Hammett. Good morning, sir. You have an arrest warrant from Palm Beach County, Florida. The warrant was issued May 29th of 2025. The charge is failure to appear for plea conference, grand theft, resisting an officer without violence. So I will appoint the public defender's office for you. Unfortunately, there's no bond on the warrant. You're going to have to wait up to 15 days for Palm Beach County to come pick you up. The reset date here is October 20th to make sure you get transported there. But I think they'll come once a week. You'll probably go sometime next week. Have a nice day, sir.
Yes, so
Thank you, sir. Next is Roberto Delgado.
Austin, for the sake of your bingo, please pay attention to the camera right now.
I'll need the Spanish paper.
Thank you. Spanish, please. Good morning, sir. You have an arrest warrant from Martin County, Florida. The warrant was issued August 21st of 2025.
Yes, ma'am.
Buenos días, señor. Usted tiene una orden de arresto del condado County en Florida. Esta orden de arresto tiene fecha del 21 de agosto del 2025.
The charge is failure to appear for driving without a valid license.
El cargo es por incomparecencia para una audiencia por manejar sin una licencia válida.
And also, you have a bond. It's $5,000.
Y también usted tiene una fianza por $5,000.
Okay.
Look in the other drawer. Yeah, also, no, I checked. That wasn't there. Look at the one underneath. Need the key? It's the middle one. The middle. Okay, one second. So if you're able to post a $5,000 bond, you can get out of jail, post it at the jail you're located at. But if you don't have any money to post a bond, you're going to have to wait up to 15 days for Martin County to come pick you up.
Así que si usted puede pagar la fianza de $5,000, usted puede salir en libertad. Y puede salir de libertad de la cárcel donde está ubicado. Pero si usted no tiene ningún fondo para poder pagar la fianza, usted va a tener que esperar 15 días para que el condado Martin venga a recogerlo a usted.
No, yo estoy poniendo la fianza.
No, I am already posting the bond.
Okay, well, have a nice day. Make sure to keep all future court dates over in Martin County.
Your Honor,
Bueno, que tenga buen día. Asegúrese de que usted se mantenga al día de todas las fechas para presentarse en corte en el condado Martin.
Ok, muchísimas gracias.
Thank
Okay,
you.
thanks a lot.
We got more warrants.
Ashley throws down 10 memberships. Thank you so much, Ashley. She's got some interesting people with this one. Some guy named Jesus Friak. I'm pretty sure that's how that's pronounced. She got the astronaut John Glenn. Some dude named Lunch Bucket. Very cool. Thank you.
Deadly weapon. So I will appoint the public defender's office for you on this warrant. Unfortunately, there is no bond and you will have to wait up to 15 days for Broward County to pick you up. The reset date here is October 20th to make sure you are transported there. And Broward County usually comes once a week, so you'll probably go sometime next week. Have a nice day.
Yes, I got a
What's
I
it?
got a question for you. So when I get to Broward, they don't give me a bond?
It's up to the judge in Broward. You should be able to get one, but you'll have to talk to that judge in Broward, okay? Thank you.
Thank
Have a nice day. Next, we have on Metro West 5, Mr. Abdur-Rahman.
Metro West.
It's Metro West, I'm sorry. Abdur-Rahmani. Good morning, sir. Sir, you have an arrest warrant. I'm sorry, you have a hold for Broward Sheriff's Office. It says grand theft of a motor vehicle and sale of marijuana. It looks like it's a probation violation, so in order for you to be transported to Broward County, a warrant has to be issued, like a probation warrant. What I will do is set your case next week. Who's my state today? Mr. Glickfield? I don't know. Mr. Wilson, are you able to reach out to the probation officer and see where that warrant's getting signed? It's usually on the back here, a phone number.
But the probation officer, I was gonna say, I could email the state attorney, Mr.
No, see here, the probation officer McDuff, it's on the second page of the arrest affidavit. If you can call them and make sure they submitted it, I'm sure they have. I'll reset your case Tuesday. See
I
if
don't
the
have his
warrant's
information.
signed. I don't know, but let me get the date. Gonna be set in Tuesday, October 7th. We'll see if that warrant's been signed, and if it has, then we'll make sure you're on the transport list. All right, sir.
Do I have a quick question? Do I have to finish this Miami-Dade case first before I go to
Must have
Broward?
posted a bond, what's going on with this Miami case? Corrections? Do you know?
Posted the bonds. He posted the bond, Your Honor.
You posted a bond, so you're able to go to Broward on the probation warrant, but they have to have an actual judge, a judge sign the actual warrant. So that's the, I'm sorry about that. Okay, we'll see you on Tuesday. Next we have is Jaquan Chambers. He's at Metro West 6. Good morning, sir.
Grand Rising, how you feeling?
Chambers, how are you? You have a hold for agency. So what's going on? Did he just close out a case?
My case has been closed for about 18 days now. I
Really?
don't know.
18
know.
days? And they're just
This
bringing you here now?
This is what I'm trying to tell you, so you can understand my frustration.
I can understand it, and I
And
feel,
it's like,
let me listen to corrections. I know what you're saying. I need to listen to corrections. Corrections, when was his local case closed?
I have here that M25-11296 was no cross on September 16th. And his traffic case, he took a plea on
I didn't
September.
take no plea.
Will you stop talking? You're just making it go longer. You're long enough.
He took a plea on the traffic AL3JU7E. He was found guilty. Sent to hold adjudication on September 19th.
So what was that ticket number again?
A3JU7E.
AL3J what?
AL3JU7E.
And what was it charged?
It was no driver's license.
So was he sentenced to anything or CTS?
It says, found guilty by bench trial. Defendant sentenced to withhold adjudication. I don't have anything else, Your Honor.
So he should have been on our warrant calendar on September 22nd. Can you explain to me why he wasn't brought here on September 22nd?
I don't know. And the warrants, there are 2 holds from Hillsborough County. There's no warrants yet. They're holds, and they were added to his jail card May 12th.
Fine, I'm going to release him on his own for cognizance. Prepare an order, please, Mr. Wilson. They have had, the hold was issued on May 12th. It's now October 3rd. They have failed to have a warrant issued.
You have both warrants, Your Honor, from Hillsborough?
No. Let me look at the other one before I do that. Thank you. Oh, let me see. It looks like it's a probation violation. Are you sure? Do you want me to reset it in the afternoon? Maybe the state can reach out to see if they've signed a warrant and it's not in the system. I don't know.
They have more than enough time.
Would you have it if it was issued? Let me just say, hold, it says possession of a controlled substance, hold for Hillsborough County, and then failing to remain at liberty without violating the law. It says committed the offense, something about abandoned property, petty theft, resisting without, as alleged in Miami-Dade County. He's on probation. What happened with his
I beat it.
Oh, you did? Did he? What happened with that case?
With the felony case, it was bind down to a misdemeanor.
And what happened? He was found guilty? Or
5.
No? It was no process.
It was
ROR, release him on his own with cognizance, prepare an order. Sir, what is your address where you live so they can get sentenced to any future court dates?
327 Northwest 47th Street.
Wait, 327 Northwest
47th Street.
47th Street. Is that the house or apartment?
It's a house.
Miami?
Yes.
You know the zip code?
33127.
Thank you, sir. So I'll release you, and I'm going to release you, and they may issue a new warrant. You want to stay in touch with your probation officer. It's a lot quicker if you surrender up in Hillsborough County, because otherwise they have to transport you there if they're going to go forward on a violation, just so you know.
No problem.
All right?
You
I'll
have
take care of it. All right.
warrant, Your Honor?
Both warrant numbers. So I have a hold for Hillsborough County.
Uh-huh.
I don't see a warrant. Do you have a warrant?
I have hold for Hillsborough County, reference aggravated assault with a weapon, no intent. Warrant number F2013.
What is it? F20-13690?
Yes.
That's a hold. But it's reduced to a warrant? It says hold. It doesn't say reduced to a warrant.
No, they're holds. They're both holds.
Judge, is this for Mr. Wilson? I only have one.
And the other one is Hillsborough County reference possession of controlled substance, warrant number F23-05064.
This is possession of a controlled substance?
Yes.
Oh, I have there on the second page. Okay, I have them both. All right, make sure you do an order and it's a hold.
ROR both?
ROR both cases, yep. Make sure you keep your future court dates. Thank you, sir. Sorry about that.
No problem.
Brought you here sooner because they haven't done releasing you.
Okay, so I'll be released today?
I hope so. Once I send you one, hopefully I'll
Oh.
send
All right, no problem.
you your
Have a
club.
good day.
Thank you, you too.
Just-
Next, Randolph.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. It is Super Friday, so happy Super Friday to you. Thank you to everybody who thus far has gifted memberships and giving greater exposure of what we do here to others. I very much appreciate that. Let's go to Michigan, and we'll spend a little time with Judge Middleton. He is doing pre-trials, I believe.
Mr. Bayo, do you happen to speak any Indian dialects?
No.
All right, we could use some help there, but we'll do the best we can. All right, thanks for your help this morning, Pablo.
Thank you. All right.
Bye. All right, you're Jose Manuel Munoz.
Yes.
Here with your lawyer, Mr. David Moore. You got charged with operating while intoxicated. As you can see, we get a lot of those. It is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. The prosecutor here from the city has agreed to reduce this to a charge of impaired driving. That is a misdemeanor punishable by up to 93 days in jail, fine of up to $300. Most important thing about impaired is it allows you to keep a restricted driver's license to drive back and forth to work. Do you understand the charge?
Yes.
Are you going to plead to that lesser charge of impaired driving?
Yes.
Let me find your file here. All right, I don't have an advice of rights here, so I'm going to take a minute. Do you understand that by pleading to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes, I do.
If you had a trial, you'd have the right to be represented by an attorney. You've retained Mr. Moore, that's fine with us. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. And you would have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes.
All right, were you driving a car at about 10 o'clock at night in Sturgis on August 17th?
Yeah.
Wow. You're going 80 miles an hour on Lakeview Avenue? No wonder they pulled you over. Had you been drinking?
Yes.
What were you drinking?
Vodka.
What was the blood alcohol here, Mr. Moore?
Judge, I don't have this. I believe it's 0.168.
Where were you going?
I was actually on the way home. And when I sped up was when I noticed there was a police officer behind me. And I thought it was like being followed, but it was an officer.
All right, Mr. Moore, does November 3rd at 11 work for you?
Yes.
Looks like you've already got a victim impact
Yes.
Thing there. All right, you're already on it. All right, Mr. Munoz, what do you do?
I currently work at Jayco and I have a part-time at Boost Mobile.
All right, we're gonna set this for sentencing for November 3rd at 11 o'clock. We'll get some more information. And I want you to take this form out to the court office, and Mr. Moore, and you will, what you'll do is you'll meet with the probation department at about 9:30, and then we'll all come in at 11 and do the sentencing. But they will schedule that with you. All right, you're good to go, sir. Let's then do Brian McDowell Jr. That's file number 251792. Good morning, sir.
Good morning.
All right, I had to parse this out. You're Brian McDowell Jr.
Correct.
And you're charged with operating while intoxicated. And I thought that you'd had one before, but I think that was your father.
That sounds about right.
I don't think that was you. At any rate, you're here with your lawyer, Mr. David Moore, and the matter has not been resolved. Mr. Moore is asking that I set this for a final pretrial. Is that correct, Mr. Moore?
That is correct.
Mr. McDowell, let me see if you owe me any money. This was 10 o'clock at night, Wilbur Road and Hess Road. I'm not sure exactly where that is. Refuse a preliminary breath test. Do we have a blood result yet?
Yeah, it was 0.14.
All right, Mr. McDowell, I want you to stay in contact with your lawyer. We'll set this for Thursday afternoon at 2 o'clock. Looks like we're gonna have some busy Thursday afternoons. And you're good to go. All right. Mr. Workman, let's talk about your case. This is file number 251688SD. People versus Aswin Kumar Patel. Mr. Patel is here with his lawyer, Mr. Justin Workman. He doesn't have good English, and I don't have good Gujarati, which is an Indian dialect. And we don't have a translator here today to translate that. The charge is operating while intoxicated with a high blood alcohol level. Prosecutors agreed to reduce it to operating while intoxicated. Is your defendant going to plead to that charge?
He is, Your Honor.
All right, what I proposed is we set this all for the same day for plea, screening, and sentencing. And we will use language line and line up an interpreter to do this. So does Jordan Yancey's day, November 10th at 11 work for you?
It does, Your Honor.
For plea, screen, and sentence. We'll need interpreter. I got this email at 7:46 this morning, so we hadn't done anything to line up an interpreter. Does he have family here?
He does. He has his wife and his daughter here, and they are who've been helping me translate through these discussions in the chambers.
What, do you speak English?
I'm his daughter, yes.
Yes, thank you for your help. This Gujarati, is that how you say it?
Gujarati.
Gujarati, and it's an Indian dialect?
Yes.
All right, I'm sure Language Line has a interpreter for that, and we will get one that day. All right, you're good to go.
Thank you.
That's November 10th at 11. Mr. Felt, let's do your case. All right, I'll just keep plugging away here. I have 2 chocolate chip cookies calling my name from Yoder's. Who's got the case with the child out there? It's hard enough for all of us to wait, let alone a young child. I try to do that one. All right, let's address this case. This is People versus Mason Scott Schuster. That's you, sir?
Yes, sir.
You got charged with operating while intoxicated with a high blood alcohol level. Let's allege you were driving at M66 near Wassippi Road.
Yes, sir.
An Amish country, and you had a high blood alcohol over 0.17. That is a misdemeanor. The prosecutors agreed to reduce it to a charge of operating while intoxicated. That is a misdemeanor, punishable by up to 93 days in jail, a fine of up to $500, carries 6 points, and requires that your license be suspended. If you get convicted of this, you're going to lose your driver's license, you understand? For a period of time.
Yes, Your Honor.
All right, you heard me go through the advice of rights here just a moment ago. Do you understand you'll be giving those rights up by entering this plea?
Yes, I do.
All right. This was not good. You were driving down M66. Where were you going?
I headed home from Kalamazoo.
Where were you at Kalamazoo?
Just around. I had gone up there to go to a Halloween party, but never went to it.
Oh, this was October 31st. Says 25. That's not correct. It's October of 24. What were you drinking?
Michelob Ultra.
That is currently the biggest selling beer in the United States.
Really?
It usurped Modelo. I think when they started to deport people, the Modelo use went down. It was Bud Light. They had their fiasco. And so the largest selling beer in America is something that has very little taste, which is a reflection on America, I guess. Anyway, you had a lot of them because your blood alcohol was 0.178. Do you accept that?
I do.
Also, you had a vodka Red Bull. That'll help too. You crashed into an Amish field and unfortunately nobody was hurt.
Mhm.
Somebody did go to the emergency room.
Mhm.
Oh, boy. Well, you're lucky they didn't charge you with a felony.
Yeah.
There were 3 males occupying the vehicle. Mason Schuster was determined to be the driver. Marion King was the front seat passenger and Kirsten Richards a backseat passenger.
Marion was in the back. Kirsten was in the front.
All right, well, they got it backwards. Kirsten was transported to Sturgis Hospital emergency room. He later advised of lasting effects from a head injury. That's called operating while intoxicated with a serious injury, which is a felony punishable by up to 5 years in prison. So Mr. Felt must have pulled some rabbit out of a hat to get this plea. All right. Well, let's set this for sentencing.
Your Honor, if I may.
Yes.
I have one matter already set for the October 27th. If this would fit.
Now let's take a look.
And if not, I'd ask it be the November 10 date.
Who do you have that day?
I'm Cheapers. I was afraid you'd ask, and I've been sitting here thinking about it. I just don't recollect.
Tim George has several. You have Brian Vladimir Chacon Matozo. That'll be an
That sure sounds familiar.
All right, we'll cram it in there at 11 a.m. on October 20. Well, the problem is that puts a lot of stress on the probation department to do 4 of these on the same day. So let's go with November 10th. I can go late to lunch, but it puts stress on everybody else. What do you do, Mr. Schuster?
Usually private contracting, but I'm looking for something different right now.
Private contracting for what?
For home remodeling.
Okay. I asked people what kind of beer they were drinking because A, I'm nosy, and B, it makes a difference on some beers have more alcohol in them than others. And this one has a relatively low alcohol content, so it takes a lot of them to get to that level. Mr. Felt, I'm going to ask you to take your client out to the counter with that. One thing I learned is the Amish kids drink Bud Light and the Mexican guys were drinking Modelo, although we had a young Mexican guy today who was drinking Bud Light. All right, Mr. Schuster, I will see you on November 10th.
Sounds good.
Thank you, Judge.
All right, let's change things up a little bit. Let's go to Judge Mercer and watch his first appearances today.
We have Mr. John McDaniel, Assistant Public Defender at the jail. I know that you can see and hear him. I want to make sure that you can see and hear the prosecutor, Mr. Mitchell. So I'm going to ask that he introduce himself.
Greg Mitchell on behalf of the state.
Thank you. Audio and video working good, Corporal?
Yes, sir.
Perfect. First case. We do have one person that has friends or family here. Mr. McDaniel, that's Isaac Lee. Mr. Lee, good morning. Mr. Lee, your wife is in the courtroom, sir. You're here because you've been accused of one count of armed burglary, one count of felon in possession of firearm, and one count of grand theft of a firearm. Mr. Lee, there is probable cause for the charges. I will say that when I read the complaint, it was kind of a close call on probable cause. I think there's enough there for probable cause, but there's not an overwhelming amount of guilt or evidence of guilt in the complaint. So obviously that's a factor for me to consider for bond purposes. What hurts you is your criminal history is terrible. I think you've been to prison 4 times. Is that right, Mr. Lee?
Yes, I did my time for that.
All right, so I'm going to set you a bond, but let me listen to the attorneys before I set that bond. Mr. McDaniel, anything on behalf of Mr. Lee?
We just asked for a reasonable bond.
Mr. Mitchell?
Nothing at this time, Your Honor.
All right, Mr. Lee, you've got that armed burglaries. I think that's a first-degree felony. I'm going to, for bond purposes, I'm going to treat these as third-degree felonies, even though they're higher degree. But the reason I'm doing that is, as I mentioned, there's some evidence, there's probable cause, but it's not a overwhelming amount of evidence. Your bond's going to be $5,000 on each count. Your total bond is $15,000 cash or surety. Cash or surety means you can go through a bondsman. Whatever you negotiate with a bondsman is between you and them. You don't have to come up with all that money. You do have a condition of no contact with that location that this charge allegedly occurred. It was one of the hotels here in Mariana. So, Mr. Lee, what's going to happen, sir, is you're going to get to use the phone. I'll answer that question for you. You'll get to use the phone in just a second or just a few minutes, and you can try to post that bond, 2548. And I'm going to tell you the hotel this allegedly happened at so that you can know that you can't go back to that property while this case is pending. Let me ask your wife if she has any questions while I'm pulling that up. Ma'am, you have any questions, ma'am? No, Mr. Mitchell?
It's the Super 8 Motel located at 2226 Highway 71.
Thank you. So no contact with that Super 8 Motel. Mr. Lee, the other thing I'm going to do is ask the jail to give you a notice for your court date. That would be November 4th at 8:30. They're going to give you that notice, and you'll get to use the phone in just a few minutes, sir. Do you have any questions?
Yes, I have 0 phone numbers. I can't even contact my wife. I have 0 phone numbers.
All right. Is that, you have a question? You want?
Yes.
You want
my wife's phone number.
She.
Here, if we want to do it where we don't get it on the record, I could text Mr. McDaniel his wife's phone number.
Mr. Mitchell says he'll text Mr. McDaniel your wife's phone number if that's okay with you and her.
Yes,
sir.
Is
that okay with you, ma'am? So your wife's going to give the phone number to the prosecutor. The prosecutor's going to text it to your attorney right now, okay?
Okay.
I wish you the best, Mr. Lee.
Yes, sir.
You'll get that phone number in just a minute or two. You can go ahead. No, I was just telling him it'd be a minute or two. No, go ahead, please, Mr. Mitchell. Thank you for doing that. Corporal, I think a camera may have got knocked off a little bit. We can barely see Mr. McDaniel. If it needs to be shifted to your left when you're facing the camera, not zoomed in, but yeah, that's better. Thank you. I can see it. Whoa.
Right about there?
Yeah, that'll work. That'll work. Thank you. Richard Smith is next. Actually, I think Mr. Smith, I got a text, Mr. McDaniel, from you saying that he was not going to be participating in the first appearance.
Yeah, it's not that he's just going through some issues. I let him know there's going to be a hold up on, and I'm going to let Elizabeth Simpson know where he's at, and we just have to go ahead and first appearing.
Perfect. Mr. Mitchell, anything?
I think all we need to do is just give him his pretrial date.
All right, thanks. Sounds good. So it is no bond on that warrant, and his pretrial looks like it's going to be October 21st. And thank you, Mr. McDaniel, for notifying his attorney. The next case we have is William Bauer. Bauer, good morning. Mr. Bauer, you're here because you've been accused of 1 count of aggravated assault on law enforcement officer, 1 count of resisting an officer without violence, and 1 count of approaching a first responder with a specified intent after warning. Those second 2 charges are misdemeanors. The first one's a felony charge. And Mr. Bauer, as far as I can tell, you're entitled to a bond. There is probable cause in the complaint. I'm going to listen to the attorneys before I set your bond, sir. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
Nothing at this time, Your Honor.
Mr. Bauer, that I'm going to set you the normal bond I would set for these charges. That third-degree felony bond's $5,000. The other 2 are misdemeanors. Their bond will be $2,500 each. You have a total bond of $10,000, but it's cash or surety. Cash or surety, Mr. Bauer, means you do not have to come up with all that money. You can go through a bondsman. That's what a surety bond is. And you'll get a chance in just a few minutes, sir, to post that bond by using the telephone, call whoever you wish. Mr. Bauer, you do have a court date of November 4th at 8:30. The jail will give you a written notice. If you post bond, they'll give you that notice before you leave the jail. Mr. Bauer, you will not get a notice in the mail. That notice they put in your hand will be the only copy you get. So make sure you show up for that court date. Mr. Bauer, do you have any questions?
No, sir.
All right, sir. Wish you the best.
Thank you.
Darla Simcoe. Ms. Simcoe, good morning. Ms. Simcoe, you're here for first appearance accused of 1 count of trafficking in methamphetamine, 1 count of possession of methamphetamine with intent to distribute, and 1 count of possession of drug paraphernalia. Ms. Simcoe, there is probable cause in the complaint for these charges, which I know allegedly occurred about a month ago. Ms. Simcoe, a little less than a month. Ms. Simcoe, as far as I can tell, you're entitled to a bond. But I want to listen to the attorneys before I address that bond. Mr. McDaniel, anything?
Your Honor, I would just, ask for a couple issues, I guess. Issue number 1, it appears like this is based primarily, if not exclusively, on the smell of marijuana. And I know there's new case law on that, but there's also older case law, that has to be pieced together about it. Also happened in September, and I'm not sure why the deputy who wrote this complaint then went out there and arrested her at her house, and it's been a month and has never asked for a warrant on the case. So there is a presumption that anytime that you take items from someone or arrest them, or essentially you take someone, there's a presumption that it's unconstitutional unless the complaint has enough information into it as to why the taking was constitutional. And I'm not sure if the complaint even just basically based on the smell is enough. But then to go out there and arrest her a month later at her house without getting an arrest warrant creates some issues, I guess, Your Honor.
Mr. Mitchell.
Nothing at this time for first appearance purposes. I'll keep it like that.
So, Ms. Simcoe, I'm not aware of any law. There isn't a law that requires a warrant if the officer has probable cause that the felony's been committed. Under the old system, the state attorney's office liked to review warrants, review cases, and they would ask for a warrant. This kind of case, anything more than a day old, that changed probably a month ago. The state attorney's office no longer requests to be involved in the warrant review process. So sometimes officers don't get warrants if they don't have to. I disagree with Mr. McDaniel. Mr. McDaniel, if there's some case law, I'd love to see it, but I don't think an officer has to get a warrant if there's probable cause for a felony. Secondly, at the time this stop was made, the law is different than it appears to be today because Mr. McDaniel provided us a case that was issued 2 days ago from the Second District Court of Appeal that reverses their opinion from the Owens case, which was the end of last year. So before 2 days ago, there was a split among the district courts of appeal on smell of marijuana being the basis for a search. That appears to be no longer the case after 2 days ago. However, even after 2 days ago, smell of marijuana cannot be the sole basis for the search. And there are other bases for this search that the officer alleges, specifically the officer alleges that you admitted someone had been using marijuana in your vehicle. That's what the complaint alleges, ma'am. And that is a separate additional basis in addition to a smell. So I think there's clearly probable cause. I'm going to set you a bond of trafficking that normally would set for the amount of $50,000. Possession with intent to distribute will be $15,000. Possession drug paraphernalia will be $2,500. Your total bond, Ms. Simcoe, is $67,500 cash or surety. You have a condition of random urinalysis. Ms. Simcoe, if you do post the bond, ma'am, you have a condition of random urinalysis. That, ma'am, you can be aware that you're probably going to be drug tested at some point. So that's going to happen very likely. You're also going to get a notice for your court date, which will be November 4th at 8:30. And you're going to get a chance to use the phone in just a few minutes, ma'am, to try to post the bond. Lastly, I am taking into account your criminal history, which is very lengthy. Ms. Simcoe, do you have any questions?
Yes, sir.
All right, man. Wish you the best. Taryn Hussey. Ms. Hussey, good morning. Ms. Hussey, you're here because you've been accused of one count of methamphetamine, possession of methamphetamine, one count of possession of cocaine, one count of possession of drug paraphernalia, 3 charges in total. Ms. Hussey, I've read the complaint in your case, and Mr. McDaniel provided Mr. Mitchell and myself a case from 2 days ago, dated October 1st.
I think it's Williams v. State.
Which would have been 2 days before the arrest. That may be relevant in your case. So I'm going to ask that you listen to Mr. McDaniel and Mr. Mitchell, then we'll see where we go from here. Mr. McDaniel.
Your Honor, going back to the presumption, there's a presumption of unconstitutionality when you search someone without a warrant. And, and in this case, it's on the officer to provide enough information that would create a probable cause. And essentially, it appears the probable cause is based solely on the smell of marijuana, or if not solely, it's nothing else in there really brings anything to a probable cause that the items that they was in there searching for were there. Nothing to bring to that level.
Thank you, Mr. Mitchell.
Just a moment, Your Honor. Nothing from the state at this time, Your Honor.
So I'm not real clear. I called our law clerk this morning for some guidance on when in the October 1st, 2nd District Court of Appeal becomes final. And it really, in the bottom of the opinion, it says there's some language in there about finality at the very end of the opinion you sent, Mr. McDaniel, and that just confused me even more. So what's clear is the way that I've been reading this, because there was a split, at least before October 1st, between the District Courts of Appeal in Florida. What's clear is that you even by the most law enforcement friendly opinion, you had to have something. Well, no, that's not necessarily true. The way I've been reading those cases is you needed something besides smell. So my question is, what did he have other than smell, he being the officer? And what the complaint says is this. He had odor marijuana, allegedly, what he thought was marijuana. I asked her if there was CBD, hemp, or marijuana inside the vehicle. She admitted her friend sometimes left such items in the car and pointed to a package of zigzag cone wraps. The problem is, in his question, some of the items in his question are legal, that being hemp. So basically he asked her, are there any legal or illegal items in your car? And she doesn't answer it specifically, at least not in what he put in his complaint. Instead, she said, sometimes my friend leaves some of those things in my car. So does that, coupled with an odor that is either marijuana or hemp, based upon the law I'm reading, give him probable cause to search? And I don't know about that. Mr. Mitchell, what's your thoughts?
I'm of the same mind. I'm not entirely sure about it either.
Mr. McDaniel?
I think there needs to be more in it. I mean, obviously, I guess, and if you're, so if you take out the smell of the marijuana, and that's an action that can be used on something else, would just that other issue that he brought up be anywhere close to probable cause? And if it's nowhere close to it, with just the smell of it, raise it above probable cause? I think the answer to that would probably be no, based on those answers and the questions he asked.
I just find it hard to believe that was his exact question and that was her exact answer, because if it was, there would have to be a follow-up question. He would have to clarify. It doesn't make sense if she says there's some things in here that are legal. Essentially, that's what she'd been admitting to without some follow-up questions. I don't think that's a very It's not very well articulated at all. And I think in that kind of situation, I agree with Mr. McDaniel. Without the smell of marijuana, the rest of it's not even close. Now, the smell of marijuana can get you there, but it's got to have something to go with it. And I just don't think that's not enough, because he didn't ask the right questions or put the right answers down. Or if she gave them, he didn't articulate them in the complaint. So I'm going to find no probable cause on these charges. Now, that doesn't mean the case is dismissed. What it means, Ms. Hussey, is that if the state attorney's office and law enforcement can correct this, ma'am, by filing an amended complaint, they very well may. And that'll be up to them to try to do that. Hopefully there was a camera on. Hopefully the officer had a camera on, and the state attorney's office can see exactly what question or questions you were asked and exactly what your answers were. And if there's additional evidence, or if the state feels like they want to, if it's exactly what the officer put in the complaint and the state wants to have that heard before Judge Garcia, they certainly can do that by filing an information against you. But for right now, I think this officer missed the training that we did back in March or April. We covered this specifically in a training then, and that officer wasn't at that training, so I don't think he has been brought up to date with this changes in marijuana law that's happened in the last year and a half. So there's no probable cause today. You're going to be released from custody. I need to make sure that we've got an address for you, because if the state does charge you with an information, I want to make sure you get your court date. Is it the Dean Road address? Is that still accurate, Ms. Hussey?
Yes, sir.
Make sure you check your mail so that you don't miss your court date, ma'am, if the state does charge you. Ms. Hussey, do you have any questions?
No, sir.
Wish you the best, ma'am. Mr. McDaniel, that's everything I had on my list. Anything else with the public defender's office?
No, Your Honor.
Corporal, anything else from the jail?
No, Your Honor.
And Mr. Mitchell with the state attorney's office.
I think Ms. Hussey's case is going to be Ms. Harris's case going forward, so I'll be in contact with her regarding this case.
Okay, sounds good. All right, Ms. Williams.
21st.
Same one you gave to me. That's what he's supposed to be, the pretrial. I got it from you. Don't be trying to get me involved in that one. Is that right? October 21st?
It is.
Okay. Yeah, his was a failure to appear for a pretrial, not failure to appear for an arraignment.
Correct.
Yeah, sorry, wasn't clear. All right, so ladies and gentlemen, that concludes first appearances today.
All right, let's stay in Florida, but we'll go back and check back in with Judge Glazer.
Street Norman.
Yes.
Okay, thank you. And then somebody else here, Mr. Stratz, who are you?
Yes, Jamie Strauss. I'm a member of Temple Moses and a neighbor in the community.
Okay, thank you. I need a moment to, and also, sir, the public defender's office is appointed for you, so who's there as well? Let me review this case for probable cause.
May I ask one question?
Sure.
As a detective, will probably have this answer more than anyone. Is anyone here the witness that specifically referenced within the arrest affidavit?
I don't know. We'll get to that in a minute.
This will invoke the rule, if anything.
Oh, you're going to, is there anybody here who witnessed him a statement?
I was a witness. I was there.
Okay, so there's one person that was there. The others were not? So there's no rule to invoke if it's just one person. Let me review this. Sir, do you speak English?
Yes.
Just want to make sure you understand English. Okay. All right, thank you. So I guess I'll start first with Mr. I don't know who you want me to start with first, who wants to state it's your case? Detective, why don't we start with you? Why are you here? What do you want to tell the court?
Your Honor, we're respectfully requesting a stay-away order from the establishments, synagogues, and schools.
Eric, non-domestic stay away order, please. Okay.
This is the third incident with this gentleman. This last one, as you read, he mentioned raping patrons of the synagogue, blowing up the face of synagogue attendees. Some of the attendees removed their yarmulkes in fear. They're in fear to attend. They're in fear when they have to exit.
Okay. State, do you have any questions to Detective?
Was this the same kind of things he was doing the last 2 times he was here, including the time he was arrested 2 weeks ago?
The mentions of raping and blowing up the faces of patrons was this last one. Previous arrest involved just harassing as they were exiting and entering the establishment.
So it's escalated to more violent statements than each time he's been there?
That's correct, sir.
No further questions from the state.
Mr. Garte, do you have any questions for the Detective Castillo?
The person that you claim says that he was yelling something about raping, he says that he was saying this in Spanish.
Correct.
And and he did not understand anything else that was being said because everything else was being said in English.
The Spanish, the violando in Spanish was what he did not understand. Or in English, he did understand.
All right. But you also can understand how someone who can only hear certain things could mishear violando and violence as similar words, correct?
Possible.
Right.
Okay. Next, Rabbi Hadar, did you want to say anything?
Yes. The bottom line is this person has been terrorizing our community. They have been harassing, not just coming towards our synagogue, but coming after people. We had yesterday another situation as well with attendees with young children that he has come behind around. He's been following and coming after our synagogue and our people because of our religion. I have people that have not attended Yom Kippur services because they're afraid. There are people that are screaming the things that he is screaming, that are doing violent acts around the world and even in America. And we are requesting the highest possible bond so this individual does not come back to terrorize people living in Miami Beach, good citizens, just trying to attend their synagogue.
Okay.
In addition, he came by our school. We have children that were frightened. We have children that actually, we have families that moved here from Europe to run away from this type of terrorism, and they're not coming to the synagogue now. They're actually scared to leave their homes because they're genuinely afraid for themselves.
Where is the school? Is it connected to the synagogue?
Yes.
Thank you. All right. Next, I have Mr. Jamie Strauss. Did you want to say something?
Yes, thank you, Your Honor. I'd ask for, please, the bond to be as high as possible because the first time he was arrested, he bonded out and it was actually on Rosh Hashanah. And we're an Orthodox synagogue, so we're all walking and a lot of us have to walk right by his house. It's a bridge. There's only one way to get to a synagogue. And we're all having to find different ways to walk. He's yelled at me, my children. He's yelled at my wife yesterday. He follows us around, follows us from his balcony when we walk around so he can yell at us. Multiple people, women, children, men, asked him to please leave us alone, and he just continuously harasses us and follows us. And especially in light of what happened in Manchester yesterday, we're terrified, we're scared, and not just me with my little kids. I've heard from multiple people, our kids were afraid to go to sleep last night. This isn't right. And we don't want to just have to go back out and not know what's going to happen, especially, over a holiday, if we don't have our phones and we're walking because that's part of our religion. And then to not know and surprise, he's back out on the streets yelling at us the very next day, because that's what happened last time on Rosh Hashanah, was yelling at anybody that looked Jewish.
Did he yell at you yesterday when you were walking with your children?
No, but he was yelling at my wife yesterday on our way home from synagogue in the afternoon, as well as other people that weren't able to join this morning.
And was your wife with your children when he yelled at her?
Yes, my wife was with one of my young kids, 10 years old.
And can I jump in? There are several others who could not miss work this morning because it's after Yom Kippur, but had similar situations. We have one actually that just came in, Mr. Periante, if he's able to speak.
Sure. Also, I'm going to let Mr. Ugarte, his lawyer, may have some questions. Well, let me ask the next person speak, and then Mr. Ugarte, you can ask any questions you like. I also need to hear from the mayor.
Thank you, Your Honor.
Mr. Periante, raise your right hand and be sworn, please. Sir, I can't see you. Can you raise your right hand? Do you swear or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
I do, Your Honor, yes.
Thank you. What is your name, please?
Joshua Pariente.
Okay, what do you want to tell the court?
I want to ask the court to consider the fact that this individual lives in the same neighborhood as Orthodox Jews and we walk to synagogue. I was personally involved in an altercation with this individual on July 4th. He physically followed me to my vehicle from the supermarket, and my child goes to the Jewish school in this synagogue. So I feel scared for myself, for my child, and my wife also works in the synagogue. And this has been like the third time that this individual approaches in a violent manner, terrorizing our community, Your Honor.
Okay. So was there anything done to you yesterday?
Yesterday, no. But on July 4th, yes.
Okay. Well, that's okay. That case is not before this court. You would have to speak to the police if there's an incident there that you wish to file charges on. Okay?
Understood.
Thank you. Mr. Ugarte, I'm sorry, Mayor Minor, what would you like to say, sir?
Yeah, thank you, Your Honor. After the Rosh Hashanah incident, Rabbi Hadar and Jamie Strauss, who was on this call, reached out to me. I got our police chief involved as well. And then literally the same thing. And it got some media attention, some news coverage. And then yesterday I had the same, literally it felt like deja vu after Yom Kippur. My phone's blowing up and had to get on a call with with Jamie and the chief. We're going to have to increase police resources to that area based on this. And what's most concerning from what I've heard and you're hearing today is that despite previous arrests, it continues and it's escalating. Obviously, we're concerned and we're taking it extremely seriously here in Miami Beach.
Okay, thank you. Mr. Ugarte, do you have any questions for Detective Castillo?
No, just the one that I already asked. That's fine.
Do you have any questions for anyone else?
On Mr. Strauss, who alleged that his wife was yelled at, what exactly did he yell to your wife?
I don't know the exact words, and I cannot speak to her because she's in work right now.
That's okay. No further questions.
Okay. Now, with regard to probable cause, I don't know, he's charged with threatening or disturbing a religious assembly, and it says credible threat with prejudice. Do you have any argument regarding probable cause, Mr. Ugarte?
It's found in the corners of the A-form.
Excuse me?
There's probable cause.
I agree. There's probable cause. Sir, you are ordered to stay away from Temple Moses at 1200 Normandy Drive in Miami Beach, Florida. You're not allowed to go to that location. You must stay away from there. Do you understand, sir?
Yes, ma'am.
You are also ordered to stay away from Rabbi Hadar.
Your Honor?
Yes, sir.
Is it possible to extend the stay away order to other establishments? For example, on 41st Street, there's many establishments, many synagogues, many schools, and they're nearby, a bus away to head south. And
I understand there's a lot of synagogues here. There's a large Jewish community on Miami Beach. However, I don't believe I have the jurisdiction or authority to do so, given that this behavior or conduct, this criminal conduct, seems to be directed to this synagogue. However, I know there's another synagogue nearby that, I don't know, Ohev Sholom, I don't know what it's called. I could end.
There's multiple schools and synagogues within walking distance of where he lives, and we all need to walk by his house as well to get to synagogue.
So I think you need to call the police if he is making any statements. I understand it may be a religious holiday. You have to speak with the security guard and contact them. Also, stay away from Temple Moses at 1200 Normandy Drive. Stay away from their school as well. That's in Miami Beach, Florida. You understand, sir? These are very serious charges. This charge is a second-degree felony. Given the fact he's out on felony bond on F-25-20760 for similar incidents, the same exact thing. I'm going to set a bond. This bond's going to be $100,000. That's plus house arrest with a GPS monitor. I guess I'll do level 3 house arrest, curfew 11 p.m. to 6 a.m. That house arrest will kick in, assuming the division judge releases him. Given that he got arrested on the same charge, he's being held with no bond on his open felony. I guess the incident that you say occurred on Rosh Hashanah on early September. That's F-25-20760. So you're gonna have to see the division judge tomorrow. Your bond's $100,000 bond. Sir, if you pick up a new law violation and I'm the judge, I can assure you're gonna have a higher bond. Leave the Jewish people on Miami Beach alone. They deserve to be able to walk just in the street as anybody else. And I don't know why you feel the way this behavior is appropriate. It's not. Maybe you should get some counseling.
Your Honor, may I say something else to the court?
Yes, sir.
In addition to everything that we have heard, I also have reported as a member of the community that this individual has sent his friend to our synagogue. So I would like to encourage the court to also consider that not only he, but also indirectly approach our community through other people.
We're not allowed to have any contact with Rabbi Daniel Hadar or any of the members of that Temple Moses, either directly, indirectly, in person, in writing, by telephone, or through third parties. And you must stay at least 500 feet away from the synagogue. And if they're walking by your house, you need to stay at least 10 feet away from all of these parishioners that go to Temple Moses. Anything else?
Your Honor, that was
$100,000 bond plus house arrest, level 3, curfew 11 p.m. to 6 a.m. But he does have the hold. So the house arrest will kick in, assuming if at such time that he is able to post a bond on this case.
So a couple of things real quick. First, they've been messing around with the technology in this courtroom now for like 2 months, and they still don't have her audio right. You would think they'd be able to figure that out by now. But Dawn says in the chat, start recording everything he says and give it to the cops. Not that easy, Dawn. These are Orthodox Jews. So when it's the Sabbath and when they have temple from sundown to sunup, so like Friday night to Sunday morning, there is no technology for them. So no phones, no cars, which is why they walk to synagogue. They can't use the stuff. So unless they hire a non-Orthodox Jew to be security to walk with them and do that recording and all of that, which is at an expense to them, then there's nothing they can do if they're going to adhere to their faith. So that's the problem. And honestly, it's pathetic. I mean, you guys have heard me, especially on the pre-show, talk about my belief that we're in a little bit of a spiritual battle right now. There you go. And I am not of the Jewish faith, but that doesn't matter. There's just no reason for this kind of behavior. Anyways, let's go to Michigan. Judge Anzalone, I believe she's going to do some sentencings.
Well, hold on. All right. Hold on. So with the jail, I'm going to pop him in a waiting room real quick because I'm getting a lot of background. All right?
Yes, ma'am.
Okay. I'll be right back with you, Mr. Madrid. All right. And Zachary Davis is appearing via Zoom, and I also have Brianna Davis appearing via Zoom. So this is the date and time set for sentencing in this matter. Mr. Raines, did you receive a copy of the pre-sentence investigation from district court?
I did, Your Honor.
All right, Mr. Davis, you are Zachary Davis?
Yes, Your Honor.
Mr. Davis, you have had an opportunity to read and review the pre-sentence investigation report.
Yes.
Have you had an opportunity to review that with your attorney and discuss it with him?
I mean, I think so.
Did you speak with Mr. Raines about the information in the report?
Yeah, beforehand, like a month ago. So yeah.
Okay, and that's right. That's what Mr. Raines is supposed to do. So
yeah.
Do you need to speak with Mr. Raines anymore?
I don't think so, no.
Okay, because I can give you a breakout room with Mr. Raines if you would like one.
Not unless he needs to tell me something. I think we're good.
Mr. Raines?
Your Honor, in light of perhaps some of the hesitation of Mr. Davis, if I could have a breakout room with him very briefly, I would appreciate it.
Not a problem.
Thank you.
All right, so I'm going to open up a breakout room. And find Mr. Raines and Mr. Davis to that breakout room. Go ahead and join the breakout room. All right, Mr. Madrid, can you hear me?
Yes, I can.
Okay, if you could just speak, maybe scoot up a little bit and speak up a little bit because their room has horrible audio. Thank you. So you are Alejandro Luis Madrid?
Yes, ma'am.
Okay, so this is in the matter of the people of the state of Michigan versus Alejandro Luis Madrid, file number 23-21441FH. So Mr. Madrid, we are here on a request and warrant for probation violation. It alleges that you committed the following technical violation and that you failed to engage and complete the Monroe Salvation Army Harbor Light Program. You were transported on March 3rd of 2025 and left that same day without staff permission. That you left the Monroe Salvation Army Harbor Light Program on March 3rd of 2025 and failed to report to your probation agent the following business day. Your whereabouts were unknown. So those are the two technical violations. And then you also, and okay, so there are no non-technical violations. This is from April 15th of 2025. So Mr. Moore, this is now a non-technical violation. Is that correct? Because he's absconded over 90 days.
That's correct.
Right. So Mr. Madrid, you're currently on probation for carrying a concealed weapon, and carrying a concealed weapon carries a maximum penalty of up to 5 years in prison if you were to plead guilty and be found guilty. So you do have a right to have an attorney represent you at this hearing and any subsequent hearings. If you cannot afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
Yeah.
All right, so Mr. Glazier is here, so I'm going to open up a breakout room for you, Mr. Madrid and Mr. Glazier. Let me find you. All right, and Mr. Glazier, I'm going to add you to that room. So go ahead and join that breakout room. Thank you. Okay. All right. And Mr. Marvin?
Yes, ma'am. Yes, Your Honor.
Yeah, let me grab your file.
I do need to clarify the one file.
Hold on 1 second. Let me call the case again. Joanne gets mad, Miss Faye gets mad if I just go willy-nilly all over the place. So this is in the matter of the people of the state of Michigan versus Chad Thomas Marvin. We have three files, 25-22239FH, 25-22259FH, 25-22272FH. I have Douglas Hartung appearing on behalf of the people, Dave McCready appearing on behalf of the people, as well as Brian Fry appearing on behalf of Mr. Marvin. Let me go back and find his PSI. All right, so I have his PSI. So first, tell me the file number you need to update.
352259.
Hold on. Let me get there. No, not that one. Hold on. Okay, I'm there.
That should be 192. But
Okay. All right. So, Mr. Fry, for the record, we have updated the credit for time served on multiple files on 25-22239FH. The credit is now 198 days. On 25-22272FH, it's 154 days. And on file number 25-22259FH, it's now 192 days. You can dispute that in a moment if you would like. So, Mr. Marvin, have you had an opportunity to review the pre-sentence report with Mr. Fry?
Yes, Your Honor.
Are you satisfied with Mr. Fry as your attorney and the advice that he has given you?
Absolutely, Your Honor. Yes.
Thank you. Mr. Hartung and you, Mr. Hartung or Mr. McCready, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report? Mr. Hartung?
No, Your Honor.
Mr. McCready?
The only thing I'd mention is, as part of the plea agreement, there's to be no contact with Jennifer Allen. And that isn't reflected in the pre-sentence report, one way or the other, but I wanted to make sure that was on the record.
Okay. All right. Thank you. Mr. Fry?
No, I don't think we have anything to challenge.
Okay.
Your Honor, but I don't know if the court was able to give me a brief breakout room with him to discuss some of these changes in credit.
Yeah. Do you want to go back into the jury room here? We'll let you back.
Yeah, that's what I think.
All right. So, Mr. Marvin, your attorney is going to go in back, and I'm going to pop you two into a breakout room.
Okay.
He's already logged in. Okay. So hold on. Close some breakout rooms and then open them again. All right, so Mr. Fry and Mr. Marvin, you're in jail Zoom 3. Go ahead and sorry, hold on a second.
Barbara, on behalf of Ellie, thank you for the $5 for her treat fund. Very much appreciated.
So we're going to go back to Mr. Madrid real quick. Mr. Glazier, you received a copy of the request and warrant.
Our office did, Junior. I don't have it. I'm at home.
Okay. All right. You want me to email a copy to you?
No, I don't need one.
Okay. So Mr. Madrid, have you had enough? So you spoke with Mr. Madrid, Mr. Glazier. How
Yes,
would you
I
like
did.
to proceed today?
Your Honor, I just had one question. Has he been screened for drug court? Does it show in his file if he has?
He was in drug court.
Oh, he was in drug court. Yeah.
Okay. I think we're going to enter a plea of guilty to the violation of probation. And we wanted to have the court consider putting him back in drug court.
All right. Okay.
And I don't know how I do that, if I have to have him rescreened.
I don't think Ms. Teskey is, or Mr. Moore, I'm sorry, is he still currently a member or has he been removed? He's absconded over 90 days, so I'm assuming he's been removed.
Yeah, typically after 90 days they're removed, but
maybe Ms. Teskey could answer that better than me.
He's been removed because he absconded for over 90 days.
Yeah.
Can we rescreen him? Ms. Teskey
I mean,
can
does he
he
get
be-
new charges or is this just the violation?
It's just,
So, just the violation?
yeah.
Okay. I can talk to Teresa and the team and see how typically if it's just this charge, they're removed after 90 days because of the absconding.
Right, but they can be rescreened for admission or no?
Not on the same charge. But I'll ask Teresa. If he's gonna enter a plea, that's fine. I will do my part.
Okay, so we will determine whether he's eligible, Mr. Glazier, for sure, all right?
Okay.
All right, Mr. Madrid, do you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, so Mr. Madrid, you have heard the exact charges against you on this violation of probation, is that correct?
Yes, ma'am.
And you got to speak up for me. I'm so sorry. That room, like I said, is horrible.
Yes, ma'am.
All right, and you've had an opportunity to speak with Mr. Glazier regarding those?
Yes, I did.
Are you satisfied with Mr. Glazier as your attorney and the advice that he has given you?
Yes.
All right, now, do you understand that you do have a right to contest this violation of probation charge and to have a trial on it? Do you understand that?
Yes.
Do you understand that throughout this trial, you will be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes, ma'am.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at the trial. Do you understand all of that?
Yes.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, ma'am.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes.
How do you plead to the charge that you violated the terms of your probation by leaving the Monroe Salvation Army Harbor Light program and failing to engage and complete it? Guilty or not guilty?
Guilty.
And how do you plead to the charge that after leaving the Salvation Army Harbor Light program, you failed to report to the probation agent the following business day or any time thereafter? Guilty or not guilty?
I'm guilty.
Do you understand by pleading guilty, you'll be giving up your right to a trial, as I've already explained to you?
Yes, ma'am.
Has anything been promised you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, ma'am.
All right, so Mr. Madrid, you were screened and accepted into the recovery court program, and then you were to enter and complete the Monroe County Salvation Army Harbor Light program. Is that correct?
Yes.
And you were transported there on March 3rd of 2025, and you left that same day without permission of the staff. Is that correct?
Yeah.
And when you left that program, you did not contact your probation agent the next day or any time thereafter. Is that correct?
Yes.
All right. And you failed to report since then. Is that correct?
Yes.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. Adams, what day would you like me to use for sentencing?
Judge, that would be October 10th at 8 a.m.
So I'm going to set this over to October 10 at 8 a.m. for sentencing. Mr. Madrid, you do have a right to be present in person or to appear via Zoom. Which one would you prefer?
Zoom, please.
Okay, so I'll put that down as Zoom. All right, so Mr. Madrid, someone from the probation department will meet with you. They'll do a preset or a probation violation report. We will send a copy of that to Mr. Glazier or whoever will be handling it that day. The attorney will review that with you before the day of sentencing, and we will see you back here on October 10th at 8 a.m. Thank you.
Okay.
Thank you, Mr. Glazier.
Thank you.
All right, let's go back to Judge Middleton. He's had a pretty busy docket this morning so far.
Good morning, Ms. Heimbaugh. I told you more than you wanted to know about the Heimbaugh family when you were here last time. This is charged as a retail fraud second degree. They're working on resolving this, but it has not yet been resolved. The prosecutors and your lawyer are asking me to set this for a pretrial conference about 60 days out, which I guess would take us to early December. Is that correct, Ms. Hutchins?
It is, Your Honor.
This was a 2024 case that came up and caught Ms. Heimbaugh by surprise. The prosecutors made an offer where the defendant would do some things and attempt to resolve the matter. As I told her, they were alleged there were 6 previous incidents. And this would be number 7. But I'm not sure exactly what the deal is, but we'll set this for a pretrial, last pretrial. We'll set it in December. Have you been in contact with anybody here about the economic crime class?
We're gonna go up to the 3rd floor after we're done here, Your Honor.
Okay. I didn't know if that was them or it was our probation department, but we used to have something called the embezzler's treatment class, which is what I would have sent you, but it sort of died on the vine several years ago, but hopefully this can be resolved. Are you still on River Run Road?
Yes, Your Honor.
All right, you stay in contact with your lawyer. We'll set a final pretrial probably early December, maybe the 2nd or the 9th, whatever works for your lawyer. And you work on those other things. All right, you're good to go.
Thank you, Your Honor.
Luke, who is your resolve, or the one we're gonna set?
Ms. Stratton, Judge.
No, not the plea, the one that was gonna be a final pretrial.
Ms. Casey,
Let's do that. And then we'll do Ms. Stratton. Good morning. Just consider this part of your punishment. You had to sit here and watch this all morning and part of a judicial field trip. You're Casey Elizabeth Willis.
Yes.
I met you at your arraignment. You're charged with domestic assault. And as I told you then, that's a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. The complainant is Joan Gritzmacher, resident or former resident of your household. The matter has not been resolved. At this point, your attorney is asking me to set this for a final pretrial. Are you still at Dorset Street in Portage?
Well, no.
Do we have a current address?
Yes, Judge, I have a current address I can provide it to the court.
All right. We'll set this for a Thursday afternoon. Are you missing work right now?
No.
All right, it will be a Thursday afternoon at 2 o'clock. your lawyer is often very busy in Three Rivers Court on Thursdays. We'll find a date that works for his calendar. And I'll see you at that time.
All right,
Now,
thank
the
you.
bond conditions remain in effect. No alcohol, no assaultive behavior, no contact with that complainant. So you keep doing what you're doing, and I will see you in a couple of weeks.
Thank you, Judge.
All right, Ms. Stratton. All right, are you Cassandra Stratton?
Yes.
Ms. Stratton, you've been charged with retail fraud and conspiracy to commit retail fraud. File number is 251679. You have been in jail for 23 days.
Judge, I counted 24. There's a time served recommendation.
All right, let's see what maybe my stuff was stale. It says 22 days. Anyway, credit for time served. All right, retail fraud is a misdemeanor. It's punishable by up to a year in jail, second degree, and a fine of up to $1,000. The allegation is that you were at the Walmart or Meijer store with Chad Salmon. He's in custody too, and stole stuff. You have a previous offense, which makes it a second degree. They're going to dismiss one count if you plead to the other count, and they have no objection to time served. Do you understand?
Yes, sir.
Other than that, did anyone promise you anything to get you to plead to this?
No, Your
Or threaten you?
No.
You've signed the advice of rights here with your lawyer.
Yes.
You understand you're giving those rights up?
Yes, Your Honor.
Were you in the Meijer store last July 14th with Mr. Salmon?
Yes.
And did you guys take some? The deal was they were taking backpacks, filling the backpacks with stuff and taking them. So did you take a backpack with some items in it?
I did not know about the backpack. I stole a comb.
A comb?
A comb. I couldn't even have told you what was in the backpack until I read this list.
All right. Did you know he was taking that stuff?
I did not.
The merchandise she had in her possession was recovered at the scene.
That's not true.
They were last seen riding bicycles. All right. Well, even admitting to a comb is enough for retail fraud.
Yeah.
Yeah, you are not in a great place. Where are you gonna go if I let you out?
201 Portage Avenue, apartment 4.
All right, who's there?
Dustin Baldwin is there.
Dustin Baldwin? All right. Will somebody come pick you up? You need a bus pass to get the 3 hours.
If I could have a bus pass, that would be great.
Yeah, when you get out of the jail, I'd give it to you, but they'll take it away from you. When you go back, you could slice somebody with it. If you walk up here, I'll give you a bus pass. I'll give you the 3 hours, okay?
Thank you.
All right, 23 days credit, 23 days. Leaving 0 days to serve. There's $125 fine and cost. You're barred from Myers for 1 year. I make that $125 due by December 3rd. All right, you're gonna get out of jail. You're gonna come up here, you're gonna get a bus pass, and you're not gonna get in any more trouble for a while. And probably a good plan would be to stay away from Mr. Salmon. All right.
Thank you, Judge.
Mr. Lace is also back there.
Let's change things up a little bit. A court we don't normally go to. This is in Fulton County. This is Judge Rochelle Carnesali, and she is doing a probation revocation calendar. So let's see what's going on there.
On his mother, is my understanding, is in ICU at the hospital. He can verify that if the court will consider. I don't think he's a flight risk.
Okay, if you want to send Ms. Mondalva and my office some information about that next week, I'll take it under consideration.
Okay, thank you.
Okay, thank you. All right, Mr. Walker, that's it for today. We're going to set a formal hearing, and Mr. Adams can talk to you about what you need to do to file your bond motion. Okay, thank you.
Yes,
thanks for your patience. Hope your mom's doing okay.
thank you, ma'am.
Take care. Okay.
Thank you.
Thanks. See you, Mr. Adams.
All right.
And then how about Mr. Freeman's case?
He needs to speak with his client, Judge.
Are they?
So I think he's still in the breakout room, and if his client can be put in the same breakout room, I think.
Okay.
Like that.
Laura, can we add the client, or do we need to start a fresh breakout room?
Yes, working on it.
Okay. Hold on a second, sir. Okay, and then Mr. Green, can you hear us? Okay, so Officer Julius, Mr. Green is thinking he's no longer on probation in Fulton County. Is that correct?
No, Your Honor. He has 10 years, 7 months, and 24 days remaining on 16 SC 143498.
498. And will you just remind us both what those charges were on the 16 SC case?
Yes, Your Honor. That was aggravated battery.
Okay, and so is he on non-reporting probation? Is that why he might think it's over?
I don't believe he is. Let me double check that. Give me one second, Your Honor. I apologize.
That's okay.
Is there a warrant for my arrest?
So the probation is based on the probation revocation is based on a new case you have somewhere else.
Those charges dismissed.
You think the new charges? You think the new
need
charges?
those-
Tell me which county you had charges dismissed. Where's the case that was dismissed?
Barrow County.
Barrow County?
Yeah.
Do you know what the charges were?
Aggravated assault.
Ag assault? Okay.
I think. It's a long story. I don't really know what the charge was. I don't know.
Okay. But who told you the charges were dismissed? Why do you think they're dismissed?
Well, because I'm here.
Oh, you think because they released your hold to Fulton County, that means that the charges were dismissed?
Yeah, I assume they are.
Okay, Ms. Mondava can find out probably about that. But you're saying you'd like to come in person and see us, is that right?
Yes, I would. Because
Okay.
one, yeah, I was prosecuted illegally with intent, and I got proof. If you can show me where I'm wrong, I'll accept it. But you can't show it.
Okay.
I was illegally prosecuted, and I want to know why.
You mean for the case in Barrow County or your old 16 SC case here?
Fulton County.
Okay. Well, we're not going to be relitigating the 16 SC case. This is just, all this is the probation revocation on that case based on the
I
Barrow
don't
County
give
case.
a damn what it is. I want to be in the courtroom with the district attorney.
Okay, that's good. I think that's a good decision for you. I'm not going to give you a hard time about that.
I think
Okay,
it is
so-
too. Because
So, Ms. Mondava?
I have the right.
Can I just give
Yes.
you a little recap of what happened at the last hearing?
Yeah.
So at the last hearing, Mr. Green was represented by Ms. Levy, but he had asked to represent himself, and Mr. Green had indicated that he was okay with the revocation, but he did not want to sign any paperwork at that time because he said he was okay if he would be released. He was okay with the revocation as agreed to,
I didn't say
as recommended.
Okay, well, there's a transcript. Mr. Green, it's her turn to talk. Mr. Green, if you want to represent yourself, you got to let her talk.
And
Okay,
I can
go
send
ahead.
you, I can also.
We have the transcript. I also recall all that.
Yes.
Okay.
So, but if he wants a hearing, we will be prepared for a hearing on that issue. As you mentioned last time and this time, we can't go back on what he had pled to or what was done in a previous case. We're just here for the probation revocation right now. And I'll be ready to argue that, but I will not be ready to argue anything beyond that.
Why not?
Okay.
Why not?
Because
she doesn't. She's not required to, Mr. Green. That's not how you handle yourself when you represent yourself. All she's going to be able to argue is just the probation revocation and nothing else. That's
I'm
the
not
only.
on probation.
Okay. Well, the probation department says you are. I think we should probably be ready for an evidentiary hearing that day. And I don't have a date for you today. When Ms. Aguirre gets back, we'll set that down.
Yeah.
Okay. All right. We'll see you soon, Mr. Green.
All right. Then what day?
I don't have a date for you, Ms. Aguirre. I'll set it on Monday.
You'll let me know on Monday?
Yes.
I'm not sure how they let you know in the jail. Do you know, Officer Julius?
No, Your Honor, I am not aware of how they portray that information.
I don't know, but if you had an attorney, it would be easy to let you know, but you've fired your attorney. So it should be in the next couple weeks.
I didn't fire anyone because I didn't have one.
Well, you had a public defender, but you let her
No,
go.
I did not. No, I did not because I refused to have one.
Okay, that's the same
Don't
thing.
get it twisted.
All right. We'll see you in a couple weeks.
Okay, see you then.
See ya.
Let me know what day.
Okay. And so now we're just waiting on the Freeman case.
Yes, ma'am.
I'm sorry about all this.
Oh, it's okay.
So are we finished?
Yes. No, well, where's Mr. Freeman's client? Is he ACDC also or a different jail?
Mr. Freeman's client is in Rice Street.
Okay, so we're done with ACDC then. Yep, we're done. Thank you very much. Take care. Don't worry about him.
Okay.
We're familiar with him.
All right.
Take care. Can I have a breakout real quick with Ms. Mandava and Officer Julius?
Yes.
I'm sorry, Judge, did you just ask something?
I asked for a breakout with Officer Julius and Ms. Mandava. We just
Okay,
need like
sorry.
1 minute for scheduling.
All right, we'll probably come back to them. Let's go check in on Judge Glazer. It's almost lunchtime.
Mr. Ugarte, when can I read the stay away order without her speaking with you?
Judge?
Tell her I have proof. Yes. I have a detective.
She wants you to know that that gentleman has his phone.
Right. That gentleman what?
That gentleman has his phone.
That I stole. Okay, ma'am, this is just allegations. Will you just listen? You're ordered to stay away from him because it's alleged you put him in a chokehold. We'll take a chokehold, then snatched his phone. There's no probable cause for the tampering. You're ordered to stay away from the alleged victim while this case is pending. The division judge can change it. Stay away from JH, the alleged victim. No contact with him directly, indirectly, in person, in writing, by telephone or through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim, his home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permitted to the nearest police department. Follow receipt with the court, and you may return to the victim's residence one time only within 48 hours of your release from jail. You must be accompanied by a police officer so that you can retrieve your personal clothing items, medication, personal and business-related paperwork, and work tools. If you go to the victim's home without police, or if you stay there, you will be arrested. Do you understand the stay away order?
Yes, ma'am.
Okay, thank you. Does she have any priors? I don't know what my paper is.
Yes, she does have some priors. It looks like it's mostly from about 10 years ago, though she did have a domestic violence battery against an elderly person 4 years ago.
All right. So, ma'am, you got some money to post a bond? I don't mind lowering it for you. I'll set your bond. Count 1, it's $2,500. Count 2, no probable cause, release outright.
How could I get in contact with people?
What? Next case, Carltha Ballum.
Good morning, Judge Glazer.
Good morning, ma'am. You were arrested for attempted aggravated assault with a deadly weapon. I will appoint the public defender's office for you. Actually, it's not an attempt because you were on top of the victim holding a knife and swinging it towards him. It's a completed aggravated assault with a deadly weapon. Ma'am, you live with him? Yeah, you have to find somewhere else to live. You got somewhere else you can stay?
So I'm asking you, I was asking where else I can go.
What? Anyway, ma'am, you are ordered to stay away from the alleged victim, Althoe Leonard Tate. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. I guess I have to wait till she finishes speaking to Mr. Ugarte too, so I can read the stay away.
Excuse me, I really.
What?
Thank you.
You ready? I don't want to interfere with her speaking to her attorney.
Judge?
Yes?
Go ahead.
Thank you.
Can you tell her?
So, Miss Bell, am I going to read the stay away order to you?
Yes,
You're
ma'am.
ordered to stay away from the victim, Althoe Leonard Tate, no contact with him either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim's home, school, and place of employment at all times.
Okay.
Do not engage in any criminal activity. Do not use or possess illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and a concealed weapons permits to the nearest police department and file a receipt with the court. You may return to the victim's residence one time only within 48 hours of your release from jail. You must be accompanied by a police officer so that you can retrieve your personal clothing, items, medication, personal and business-related paperwork, and work tools. If you go to the victim's home without police, or if you stay there, you will be arrested. Do you understand the stay order?
So Judge, she's asking for your release of pretrial services because she has an autistic nephew that she picks up at Easter Seals every day.
I don't know what you're saying. I can't hear you.
Sorry. She has a nephew she picks up from Easter Seals who's autistic.
You want house arrest? They can't give a pretrial.
You know, we would ask for pretrial, but
I can't, based on this. I can do house arrest with a GPS monitor. Did any objection?
No, Judge.
Right, house arrest alternate bond, it's $5,000. I'll do level 3 house arrest. Curfew from, what time do you have to take him to school, or you just pick him up?
I just picked him up.
Okay, house arrest, GPS monitor, level 3, curfew from 11 p.m. to 6 a.m. Okay, have a nice day. Stay away from the victim.
Love you.
Next is Jacqueline Solis. Oh, hi, Miss Solis.
I don't know if Judge Glazer is getting hangry, but it seems like her audio equipment definitely is. They really got to get that sorted. As her day goes on in that courtroom, her audio gets worse and worse. But again, they've been working on that room for like 2 months. You'd think they'd have it figured by now, but who knows. Let's go back to Michigan. Judge Anzalone is about to do another sentencing.
Thank you for your patience. All right, so we are back in the matter of the people of the state of Michigan versus Chad Marvin. Mr. Fry, have you had ample time to speak with your client?
Yes, Your Honor.
All right, are you ready to proceed then?
Yes, Your Honor.
All right, so Mr. Marvin, have you had an opportunity to read and review the pre-sentence report?
Yes, Your Honor.
Have you had enough time at this point to discuss that with Mr. Fry?
Yes, Your Honor.
Are you satisfied with Mr. Fry as your attorney and the advice that he has given you?
Yes, Your Honor.
Mr. Hartung, I'll start with you. Do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Mr. McCready?
Other than the no contact provision with Jennifer Allen, no.
Yep, okay, I wrote that down. Thank you. Mr. Fry?
No, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? Mr. Hartung?
Not that I'm aware of.
Mr. McCready?
Not that I'm aware of.
Mr. Fry?
I don't believe so, Your Honor.
All right, so let me get back to the PSI. Okay, so starting with file number 25-22239FH on the count 1 controlled substance delivery manufacture of methamphetamine. The probation department has calculated the minimum sentencing guidelines to be 78 to 130 months. On that same file on count 2, firearms possession by a prohibited person, they calculated the guidelines to be 12 to 24. And then on file number 25-22272FH, possession by a prohibited person, they calculated the guidelines to be 12 to 24 months. I'm just doing this pre-sentence report first.
That's count 2 should be 9 to 23, I think. On the 22239.
Well, let's see. 12 to 24. Oh, yep, it is 9 to 23. So I'm sorry, I misspoke. So 25-22239FH, the possession of a firearm by a prohibited person. The guidelines on that were calculated to be 9 to 23, probably because there were 2 counts on that file. I think, but then on 25-22272 FH, the same charge, the guidelines were 12 to 24. So, Mr. Hartung,
I'm satisfied with the guidelines, Your Honor.
Mr. McCready.
I'm not on either one of those cases. I'm on.
Oh, okay. I'm not sure
2-2-5-9.
which is which. So,
Sure. I'm on.
Mr. Fry.
Yeah, we're not contesting the guidelines. Your Honor.
Okay. And then Mr. McCready, on your file, file number, let me get back there. File number 25-22259 FH, on the assault with a dangerous weapon, the guidelines were calculated to be 14 to 58. Mr. McCready?
That is correct.
Mr. Fry?
Yeah, we're not contesting the guidelines.
Okay. All right. So, Mr. Hartung, on file number, you're on file number 25-22239 and 22272, correct?
7-2 file, it's Mr. Sneed's file, but I'm here for him today, Your Honor.
Okay, so many prosecutors. All right, is there anything on those files, Mr. Hartung, you wish to say on behalf of the
And I think I want to yield to Mr. McCready initially because he is a victim in his case. And I think that's probably the more important situation, and I'll address mine after that.
Okay, so we'll move on then to file number 25-22259 FH. Mr. McCready, is there anything you'd like to say on behalf of the people?
Yes, as we just went over, the guidelines here are 14 to 58, and that's on the felonious assault when we had already dismissed a home invasion first degree. So he's getting a real big break here. I agreed to the no upfront MDOC incarceration because, you know, to make a global resolution with the other two files. But the key here is the no contact with Jennifer Allen, whether she wants the contact or not. I'd like the court to make that clear to Mr. Marvin. And again, I don't know if the court remembers this, but he was on bond in this case and was arrested at her home while he had a no contact provision with her. So I want to make it very clear that if he does have any contact with her going forward during the probationary period, we would be asking for a substantial prison sentence.
Okay, got it. So Mr. Fry, on this file, is there anything you'd like to say on behalf of your client?
So, Your Honor, Mr. Marvin is obviously facing sentencing here on a few different files, and I think this resolves all things that he has outstanding. There is a plea agreement on all the files that, you know, his sentence would not include MDOC. So we'd ask the court to follow that plea agreement as it relates to all these files when determining appropriate sentence. Mr. Marvin, you know, obviously has almost just shy of 7 months credit, it looks like, you know, on these at this point in time, or 6.5 months or so. So Mr. Marvin, as stated in the PSI and stated when he entered his pleas in this case, has a substantial drug problem, specifically with methamphetamine. As he indicated that he was using approximately 7 grams of meth per day, which, you know, has led him to a lot of these issues that he's facing with problems with his relationships, breaking the law, landing him in jail here today. You know, and it could land him in prison potentially, you know, if he doesn't change his behaviors going forward. But he has committed to me that he wants a serious life change going forward. It'll obviously be up to him whether he follows through on that. But he has indicated that one big event for him that has happened is he has his first child on the way. due in January. And he is wanting to make some significant changes, you know, to be a role model for that child, a parent for that child going forward.
Is Jennifer Allen the mother of that child?
No.
Really? Okay.
So, yeah. So it's not Jennifer Allen, so we should be good on that. But he does have that child on the way, due in January, Your Honor. Also, he lives locally here in Lenawee County. He has a house on a land contract that, because he's been in jail, there was just a forfeiture judgment entered on the 30th. So he has a limited amount of time to redeem the property at this point in time. So, you know, obviously he can't do that if he's continues to be incarcerated in jail, but that, you know, having stable housing certainly would help with his road to recovery, raising his child, and, you know, just maintaining sobriety. So, Your Honor, my client, you know, would ask to be placed on probation in this case with some terms that would help him deal and keep him accountable on the drug issue, so he stays clean, stays sober, and maintains this lifestyle that he has indicated that he wants going forward. We would ask that the court either consider placing Mr. Marvin on probation today and releasing him with credit for time served, or in the alternative, ordering that Mr. Marvin can be released to drug rehab as soon as a bed becomes available, and allow him to participate in that program if needed. Again, he's been in jail for considerable amount of time now on these credits, so he has obviously been clean while in jail from drugs, and he's indicated that his plan going forward is to remain clean and sober. And, you know, he will be held accountable by the probation department to ensure that he does follow through on that. You know, otherwise, you know, the consequences, as he understands, you know, are going to be, you know, likely severe, and, you know, he will probably lose his freedom. So we'd ask the court to consider one of those options, either starting him on probation today or allowing him to be released to a drug rehab program. Thank you.
All right, Mr. Hartung, on your file, do you wish to make a statement?
Yes, Your Honor. As we see here, the guidelines are extremely high on the charges for the PWID, possession with intent to deliver charge, and that's without the enhancement for the prior supplements. So it would have been even higher with those involved. So he's really getting a lottery jackpot size opportunity here. And I really hope he takes advantage of it. He was given this opportunity primarily because, or essentially because of what the work he did with Detective Kevin Putnam with the Adrian Police Department regarding the Brianna Soto missing persons situation. And Kevin Putnam said a lot of nice things about Mr. Marvin, the truthfulness that and the helpfulness that he was throughout that process. Still a pending investigation, but he certainly stepped up and did his share as it relates to that. As it relates to a sentence here today, I think there obviously should be a probationary sentence. And when we talked about the plea originally, we talked about him doing 12 months. I do not have an obligation or an objection to him going to rehab. I think that's a great idea for this individual. I'm hoping he does well. I know that he has a situation with his house and he needs to get that straightened around. Going to lose that house if he's not careful, or he can sell that house and get the equity out of the house, as I've spoken to Mr. Fry about, or he can try to catch it up, but it's an awful lot of money. But I do realize that he has an opportunity here with some other opportunities with an estate situation that's been described to me through his attorney. I'd like to see him be able to take advantage of that. He's continued to cooperate with law enforcement and will continue to cooperate with law enforcement, is my understanding, in investigations that he's helped on. But the main thing here is I think he needs to get into rehab. I'd like to see him get into an in-house situation. And if the court's so willing to do that, I think that would be appropriate for him at some point down the road here. Thank you.
Mr. McCready, before I go to Mr. Marvin, do you wish to weigh in regarding incarceration?
I'm in favor of what's been said already. I mean, I understand that he's got a 12 months cap on his jail time. So the inpatient rehab sounds good to me as well.
So Mr. Moore, he's been clean, incarcerated for a substantial period of time. Would he be eligible for inpatient at this point?
Well, Your Honor, this isn't my case, so I'm not familiar
No,
with
I'm
it.
just in general asking, or I guess it's Miss Holly. I'm sorry, getting you're stuck in the corner over there.
Yeah.
So he's been clean for a substantial period of time. I don't know for, would he be eligible for consideration, Mr. Moore or Miss Holly, for inpatient? If
I don't know how that works.
so, Mr. Moore.
So we would refer him, and community mental health would assess him, and then they would determine whether he would be eligible, regardless of his, how long he's been incarcerated.
All right. Okay, I know sometimes if they're out, they won't take them. Okay, Mr. Marvin, finally it's your turn. Is there anything you'd like to say on behalf of the people? Or on behalf of yourself? I'm sorry.
I'd just like to apologize to the community and to Miss Allen for my behavior for the last few years. It's been pretty bad. I take full responsibility for all of my actions. And, like Mr. Fry said, I have a home, I have a kid on the way, and I really just need to get myself together to provide for my family that's coming and the family that I have. And and I understand the magnitude of the situation. I got a huge break. I get it, and I will take full advantage of it. There's no doubt. I'm 51 years old. I don't really have any more options.
All right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for the law, and the protection of society. So on file, let me get all this straight. On file number 25-22239FH. And I'm going to back up. So Mr. Hartung, if I send him to a rehab facility, he's been clean for a long period of time. If I send him to an inpatient rehab facility, it could be anywhere from 30 to 90 days. That would really stop him from being able to get his house back and going back to work.
Well, when Mr. Fry and I were speaking about this, Your Honor, we were thinking it would be a 30-day program. And I'll be very frank. He owes so much money just to bring it current. And it's really a long shot for him to accomplish that. The thing that I've tried to stress to Mr. Fry, and I'm stressing to Mr. Marvin, is he's got equity in that home. He has legitimate equity in that home. I'm aware he does. I know he does. That property can be sold if he doesn't make it. He can't bring it current. There's some other things I know that Mr. Fry has talked about with me and also with Mr. Marvin about that situation. I don't have full access to the information, his availability to get funds, but I think he feels he has an opportunity to get some funds to possibly bring it current. But I don't want him to miss out on the equity.
Okay.
I can make it current. I just need to get out to do that, and that's the problem I have. I've tried to have a power of attorney. The power of attorney has actually tried to steal everything I own out of the home and everything that I have. So that didn't work out. Every time I've tried to get someone to help me, they basically stole all the stuff I had. So I've tried that. I really have. Trust me. There's a lot of money in the home, and like Mr. Hartung says, there's a lot of equity there. It's just that I can't get anybody to do anything.
All right. So on file number 25-22239FH, sentence of the court that we placed on probation for a period of 36 months. During that term of probation, you will obey and comply with all the articles, with all the provisions in your articles of probation. You are to attend outpatient treatment as required, drug test as required. Find another PSI that has the terms because this one doesn't. All right. Let's see. You're not to use or possess any alcoholic beverages or other intoxicants. Comply with the requirements of testing for drugs and alcohol as required. Not to use or possess any illegal controlled substances or drug paraphernalia. If you are prescribed any controlled substances by a physician, you must get permission from the probation department and take as required if granted permission. You must complete mental health, domestic violence, battery intervention, or other recommended treatment. If required or recommended by assessment, you're not to use any object as a weapon. Can't have any weapons in your possession. Can't anyway because you have prior felonies. You must submit to search of your person and property, not limited to your vehicle, your residence, your computer, without need of a warrant if the field agent has reasonable cause to believe you have items which violate the terms and conditions of your probation. Let's see, I'm going to,
No contact with Jennifer Allen.
That's not this file.
I think we should just go ahead and put that in all of them, but you know. What do you think?
I'm gonna put it on the other one.
Okay.
Okay, all right, you are to, I will give you, let me see, I'm gonna allow that you can be, all right, so I'm gonna order that you serve 1 year in jail. Hold on, Mr. Marvin. On file number 25-22239FH, I'll give you credit for 198 days. On file number 25-22272FH, I'll give you 154 days. You may be released to an inpatient program. So you won't be serving the year, but that means you go to the program, you complete the program, and do everything you're required to do. There is a restitution. There is a crime victim assessment fee in the amount of $130, $68 in state costs, $30 per month supervision fee, $60 if we have to put a tether on you, $750 in court costs. I don't think there's a DNA fee because he's already on. So that's those.
That first file has 2 felonies, so she can be 136 state costs.
Okay. And then 68 on the other file?
Correct.
All right, so $136 in state costs on file number 25-22239 and 68 on 25-22272.
And crime victims' rights fee in each file.
And a crime victim rights fee of 68 or 130 in each file. All right. You have too many files, Mr. Marvin. All right, so now we're going to move on to file number 25-22259FH. On that file, I'm going to place you on probation for a period of 36 months. During that term of probation, you are to obey and comply with all the orders of probation and all the terms that I've already gone through for your other file. I will give you credit for 192 days on that file. You are to have no contact with Jennifer Allen. I'm also going to order domestic violence counseling with Sally. Is it Welch or Welsh? I think it's Welch. But anyway, I'm going to order domestic violence counseling with her, along with any other counseling as required. On that file, there is $130 crime victim rights fee and $68 in state costs. He's already paying supervision fee on his other file, so I don't have to order it on this file. Is there anything else on this file, Ms. Holly?
The DV counseling, I usually go through John Bailey. You want it to be through Sally?
It's a long-term program.
Either way.
Well, I mean, is this, let's do John Bailey.
Okay.
All right. All right, and so anything else on this file, Mr. McCready?
No, I think we're good. Thank you.
We said no weapons and search and seizure, I think.
Yeah, yeah, okay. And, yeah, all right, anything else, Mr. Fry?
Renner, so just so I'm clear and clarify, the court, on 25-22239, gave Mr. Marvin 1 year in jail, but had ordered that he could be released to an inpatient program. If he completes that program, would he have to go back to jail or what?
No, he just reports.
Thank you.
So, Mr. Marvin, when you get to the program, I don't care if you don't like it. I don't care if you don't like the people. You just keep your head down, do what you're supposed to do, complete the program, and report as soon as you're released. All right?
Yes, Your Honor. Absolutely.
Okay. All right. Unless there's something else, I think we're all done on this. Mr. Marvin, we're going to send to you a set of your notice of right to appellate review for each file over to the jail. You're going to initial and date 1 copy for each file for our records. The other copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Okay, thank you.
All right. Thank you, Mr. Hartung, Mr. McCready, and Mr. Five.
All right, let's go back to Fulton County and Judge Carnesali. See what the next contestant has. Nope, let's not. Just as quickly as I'm going to do that, she cuts the feed. These silly judges. Judge Middleton it is then.
Are you Vernon Lee Barnett?
Yes, I am.
Mr. Barnett, you're charged with driving with a suspended license. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It carries 2 points and it requires your license be suspended. The prosecutor has agreed to reduce that to a charge of allowing another to violate the motor vehicle code. We've done several of those this morning. That one carries no points, doesn't go on your driving record, and should not affect your ability to keep or maintain your driving privileges. Do you understand?
I do understand.
Find your file. All right, the ticket was in White Pigeon. No, it was
in Colon.
At 8:20 at 7:30 on South Main. No, that's where you live. The ticket was at Borough.
It was by the apartments there in Colon.
You were also going too fast. They gave you a warning.
Yeah.
Was your license suspended at that time?
Yes, sir.
Where were you going?
To a lady I was seeing at the time. It was actually her car.
Mr. Coaches must represent Colon as well. All right, you're revoked. Have you done anything to try to get your license back?
I have, Your Honor, on occasions. I just got out. So I'm in the process right now.
We should explain, right? He is on felony probation. And he's aware that this could be a probation violation. He has discussed it with his probation officer.
All right. Are you living in the trailer park on Withers Road?
Yeah. The Withers Trailer Park?
Yeah. Who are you living there with?
Who am I staying with?
Yeah.
Myself.
Okay.
Well, you know somebody?
No, I've had several cases out there recently.
Withers?
At that park.
Okay.
They've got septic issues and other problems out there.
I didn't know that.
Well, maybe you don't have any. Count yourself lucky.
I worked a lot too.
All right, it carries a $100 fine, $75 crime victims' rights fee, $50 state minimum fee, and $150 attorney fee. That's a lot.
Yes, sure.
That's $375. 100.
Yeah.
200, 375. I'm gonna put you on a payment plan for that.
Okay.
I'd like at least $50 per month.
That'd be no problem. Yeah.
All right, I want you to go out to the counter and I'll give you one right here. Need 2 of these kind.
All right.
Then I'll get you back.
That'll take me out to the camera?
Yep.
Appreciate it. Thank you.
Okay, you're good to go. Go out to the counter. The bailiffs may be able to assist you and call them for a ride. John, while you're there, what else do you have for me?
I have, we can do one. We have Morgan Kinsey, it's going to just be set for last pre-trial.
Let's do that one. Good morning. Morgan Kinsey, file number 212533ST. This is an old case that got resurrected. And it was charged with failure to report an accident and operating without a valid operator's license. The matter was old because the defendant had failed to appear and we'd had some bench warrants and she got in trouble in Cass County and we got our case started in August. Mr. Bush, what's the status here?
We're going to set up for a last pre-trial.
Is she working on getting her license?
I don't know. That really is not our defense. So.
All right.
License.
Miss Kinsey, are you still at the Elkhart address? Is that yes?
Yes.
All right.
It's just on Old Orchard Lane?
Yes. Okay. All right, we'll set it for a last pretrial. I mean, another trip up here, but we'll see where this is headed. This is old, like I said, about 4 years old. And I don't know what the status of your license is now or what is what, but we'll work on that. I'll see you. I don't know the date yet. I will give it to you when I get it. All right, thank you. Amber Marie Ash.
This will be a plea, Your Honor.
Good morning. Are you Amber Marie Ash?
Yes, sir.
Miss Ash, you got charged on a formal complaint with a retail fraud. They allege you're at the Walmart store on February 21st and did a skip scan. Let's see. It's alleged that you took a cart full of food and other items $186.39. And the prosecutor's apparently okay doing a retail fraud deferral. Is that correct, Mr. Bush?
Yeah, and Mr. George, I think that confirmed that. That's correct.
Oh, it's an ordinance case.
Yes,
All
sir.
right. Well, Miss Ash, let's talk about that. What we do with a deferral, and I started this when I was prosecutor a long time ago. If you do what I ask you to do, they will take this charge off your record. In fact, they'll dismiss the case if you do the following things. You do the economic crime class, you pay any civil demands, and you do 10 hours of community service. And you'd be barred from Walmart during the time of this. You understand?
I do. I have a question.
Yes?
I delivered the Three Rivers newspaper, like, can I deliver that still?
Yes.
I think she's saying is, I think she dropped some off at the Walmart store.
I understand. Yes, you can do that. You can't shop in there.
Okay.
All right, so in order to do this, the first thing we have to do is have a plea of guilty. Did anyone threaten you to get you to plead to this charge?
No, sir.
Or promise you anything?
No, sir.
Were you in the Walmart store back in February with Mr. Cook?
Yes.
And did you take a shopping cart full of food?
Yes.
Is that what it was, food?
Yes.
That's probably why Mr. George is willing to do this. All right, I'm going to set this for sentencing for Monday, December 8th.
At what time,
10:30.
That's fine.
And if you've done everything by that time, you don't even need to appear.
Okay.
Procedurally, what does she need to do?
I'm
get
gonna
on
have
the-
her take this form down to the probation department.
This
Mhm.
Okay.
No. Yeah, that's it. They will explain about the economic crime class. Now, there should also be a restitution in there. They didn't recover the property. I want you to pay $186. Can I see that form? Do we know who's got the children out there? Which case that is?
I do not know the case offhand,
All
sir.
right.
One of them that I fingerprinted, I know that.
All right, Miss Ash, you take that down to the probation department. And they will get you done with today, but prep you for what you need to do for the economic crime class and community service. And hopefully you'll have everything done. We won't even have to be here on December 8th at 10:30. If you do that, the matter will be dismissed. If you don't, we'll proceed to sentencing.
Okay.
Okay.
Thank
you.
All right, let's go to Clayton County, Georgia. their first appearances, where they love to line him up against the wall. Very Soviet of them. This is interesting, though. If this has been in the background before, I've not noticed it, but they have a first aid kit and hand sanitizer handy. So, very Soviet indeed.
Going to be 1,000. The second charge is an inmate in possession of a prohibited item. That is a felony. That bond will be 10,000. The last charge is misdemeanor terroristic threats. That bond will be 3,000. So when I add all of those up, your total bond is 14. The preliminary hearing will be for the 29th at 8:30 a.m.
I didn't really get the total. Went in and out on me.
Oh, okay. The total is 14,000, and the preliminary hearing is October the 29th. And let me get your. Were you able to fill out an attorney application?
So I was able to.
Okay. You're currently incarcerated, right?
Yes, sir.
How long have you been incarcerated right now?
July.
Okay. All right. I'm going to get a public defender assigned to your case on this.
All right.
And that will take care of everything for us this morning. Yes, sir.
All right. That'll be it, sir?
Yes, sir. That's it.
All right. Thank you.
Okay. Thank you. All right. Good morning, sir. Can you state your name for me?
Bobby Wiggins Frazier.
All right, Mr. Wiggins Frazier. Let me get your paperwork here. All right, Mr. Wiggins Frazier, you've got two charges, both felonies. I'm sorry, the first one's a felony, violation of the Georgia Controlled Substances Act. I cannot give you a bond on that this morning because it looks like you were given 2 years confinement plus 3 years probation last year in Clayton County Superior Court. So I can't give you a bond on the felony. Hang on just a second and let me check one thing here. I think
I'll take a better.
413.
Okay.
Okay. Yeah, and then the same on the next charge, which is possession of a weapon or drugs by an inmate. And I can't give you a bond on that one. The preliminary hearing will be October the 29th at 8:30 a.m. And let me get your application. Were you able to fill out an attorney application? Sorry, it's breaking up. Were you able to fill out you did fill one out? Okay. I'll find it later. You're currently incarcerated, is that right? How long have you been incarcerated right now?
5 years.
Okay. All right, we'll get a public defender assigned to represent you. And that'll take care of everything for us this morning. Thank you, sir.
Appreciate you.
Thanks.
Put your hand in your old man, but he divided my probation.
All right, and good morning, sir. Can you state your name for me?
Rodriguez Whitlock.
Mr. Whitlock. All right, let me get your paperwork here.
Oh, I see the child talking about Hispanic. I see him.
All right, so Mr. Whitlock, you've got two charges here. There's possession of drugs, and that is a $5,000 bond, and the second charge of items prohibited for possession by an inmate, which is also a $5,000 bond. So it gives you a total bond of $10,000. The preliminary hearing will be October the 29th at 8:30 a.m. And let me get your application out here.
Yes, sir. Okay, thank you, sir. They went. I don't understand what's going on. Like they must have said I'm rich or something. Like they just keep giving me free world and y'all just charging me.
And I understand you're currently incarcerated.
crazy.
How long have you been incarcerated right now?
I've been incarcerated for a year and I'm here tenant 1 I'm tenant
right.
I end up with some charges on me that I don't even know nothing about.
Okay. Well, I'm gonna get a
Lieutenant,
I'm gonna get a public defender assigned to represent you, and that'll take care of all of our business this morning. All right. Thank you, sir.
All right, y'all. Y'all have a nice day. My best man. There you go. Oh my God. I call him motherfucker that. I'll be if I bring up on.
All right. Good morning, sir. Can you state your name for me?
I'm David Conley representing.
Mr. Conley. All right.
Who is that?
All right. So, Mr. Conley, you have got 2 charges here. Your first charge is a felony items prohibited for possession by inmates. That bond will be $10,000. Next charge is simple battery to a law enforcement officer. We're going to set that bond at $4,000. $14,000. Hearing will be October the 29th at 8:30 a.m. Okay. And give me just a moment to get your attorney application out here.
Excuse me, Your Honor. How does that work if I already been sanctioned here in-house? Already, I'm in the hole right now. I already been sanctioned, and I'm getting.
Okay. Well, I don't know. I don't know anything about sanctions. I just know that they have brought these charges against you.
Right. That's
so this will go to if it's bound over, this will go to Superior Court. Okay.
Isn't that double jeopardy?
I don't think there's a court system, but I think we're the court system. So you are currently incarcerated. How long have you been incarcerated right now?
Yeah, 20 months now.
Okay, so I will make sure that a public defender gets assigned to represent you on this, and that will take care of everything for us this morning. Thank you, sir.
I have a question.
Yes, sir. Go ahead.
I would like to put in for a demand for speedy trial for this case right now.
Okay, I'm assigning you a public defender. Talk to them about doing that. They can take care of that for you.
Right, but I'm already approved on the file that I can represent myself. I'm my own lawyer. Your Honor.
Okay. All right. But I'm assigning you a public defender. Talk to them about that. Okay.
All right.
All right. Thank you, sir. Mm-hmm.
Yeah, there was wait, one more and not exactly.
No, that's a middle.
Oh, what is it? Let's start with the first one. Started with Your Honor, we some of the females.
Okay. All right.
First one. First one going first screen. Everybody else see on Who's Barkley? It's you.
Yes, ma'am.
All right. And good morning, ma'am. Can you state your name for me?
Good morning, Latasha Barkley.
All right, Miss Barkley, you've got 2 charges. There's battery, family violence. That bond, I'm going to set that bond at $1,500. The next charge is criminal trespass. We're going to set that bond at $500. That's going to give you a total bond of $2,000. As I'm understanding the allegations here, the alleged victim here is your daughter. Is that correct?
Yes, sir.
How old's your daughter?
17.
She's still in high school?
Yes.
Okay. And are you her caretaker?
Yes.
Okay. On these types of charges, we would normally bar you from having contact, but given that you are her caretaker, I'm going to just put the condition in here that you are to have no violent contact with your daughter. That would allow you to go home, be around her, take care of her. But it means you can't have any more situations like what's alleged to have happened here.
Yes,
okay.
sir.
All right. So no violent contact with her. Yes, ma'am. Go ahead.
Sorry for interrupting.
That's good.
It's considered violence for trying to take a phone and not actually taking the phone. That's what is considered.
The allegations here are that you scratched her while physically fighting with her. So that is considered violence. Yes, ma'am.
That's not true. If you see my face.
So having a hearing on it, just go read what's written you can talk to your attorney about having a hearing on that issue. That's what we're going to schedule for October the 28th at 8:30 a.m. That's your preliminary hearing. Would you like a public defender?
Yes, sir.
Okay. And based on your application, I find that you do qualify, so we will get somebody assigned to represent you. And that'll take care of everything for us this morning. Thank you, ma'am.
Okay, thank you.
All right. Thank you.
1-5.
All right. Excuse me just a moment, ma'am. All right. And good morning, ma'am. Can you state your name for me?
Toya Deloach.
All right. Let's see. Ms. Deloach. Okay. And your last name's also noted as Williams in here. Is that a maiden name?
Yes.
Maiden name. Okay. All right. So let me find your paperwork here. All right, Mr. Deloach, you have one charge. That's criminal trespass, damage to property. That's a misdemeanor. The bond will be $2,000. While out on bond for the time being, you are to stay away from and have no contact with Kelton Deloach. Is that your husband?
Yes.
Husband? All right. You guys live the same residence?
Right.
All right. So for right now, you're to have no contact. You talk to your attorney. That's a temporary condition. You talk to your attorney about how to get that bond condition changed over time to start to allow contact again and allow you to go home eventually. Your husband can also talk to the victim services folks with the solicitor's office to let them know if he wants contact and wants you to come home. Okay. So that's something that can get worked out later, but talk to your lawyer about that. But for the time being, you'll need to stay away from the residence because you can't have contact with him. I will put into the bond order that you can schedule an appointment within the first 10 days of your release. You can schedule that appointment with the sheriff to get time that you would be allowed to go into this and get what personal items you need for the time being. The preliminary hearing will be October the 28th at 8:30 a.m. And let me get your application for an attorney.
All right, did you say go to victims?
Your husband can talk to the victim services folks with the solicitor's office. They're the prosecutors on the case. They would be in touch with him about the bond condition and what he wants to do. Okay, and based on your application for a court-appointed attorney, I find that you do qualify, and I will put the order in to get somebody appointed to represent you, and that will take care of everything for us this morning. Thank you, ma'am. Mm-hmm.
All right, let's go back to Judge Middleton.
What? Jonah McLean, that's Ross's. All right, we're gonna be a while. Here it is. This is, I think, number 11.
And so he has another one that has another set of kids, his class.
All right. Good morning. So are you Kamari LeVar Lockett?
Yes, sir.
We've met. I met you at your arraignment. You're charged with operating while intoxicated, as you saw. We've had a number of these this morning.
Yes, sir.
That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. The prosecutor has agreed to reduce your charge to impaired driving. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $300. And it allows you to keep a restricted driver's license to drive back and forth to work. They apparently will also dismiss no ops and refusing a breath test, which is pretty good. If you refuse the breath test, your license is probably going to be suspended anyway, but we'll figure that out further as we get to the sentence. Anybody threaten you to get you to plead to this?
No, sir.
And you've been sitting here while I've been going through advice of rights with other people. Do you understand you have those same rights?
Yes, sir.
You're giving those up by entering this plea?
Yes, sir.
All right, well, you're driving a car in Three Rivers. Where was this? 9th Street, Madison, not far from your house, on August 13th.
Yes.
Your blood alcohol was 0.165, which is 2 times the legal limit. What were you drinking?
Beer.
What kind?
Corona.
Where did you drink it?
At home.
Where were you going?
My granddaughter had run out of juice, so I was going down to the Dollar General before it closed to get her some more juice.
So you won't go very far, but far enough that you got this. Jordan, what else do you have for me?
I have that joint case with Mr. Bush and his person, and then I have a fee for Jennifer Bowe.
And what's that gonna be too?
It's just as charged.
All right, I'm gonna use that date then, the 10th of November. Where they put those in there quickly. November 10th at 11. Does that work for you, Mr. Bush?
Yes, Your Honor, that's fine.
What do you do, Mr. Lockett? You told me, but I forgot.
I'm a barber.
I remember now. All right, I want you to take this form out to the probation or out to the counter. And
Oh, okay. All right, thank you.
all right. All right, let's take up the joint case with Mr. Bush and Ms. Benton.
It's joint in that all the offers are written. Mr. Bush's.
Yeah, they're not connected, but it's all.
All right.
Yeah, I don't put everything on one form, but I think all the sheets should be up there.
I don't seem to have it. Oh, here it is. I got stuff all spread out. All right, Miss Benton. We just went through this. I'm not going to sentence you today And I still don't know what to do with you. I just put you in jail and you took your lumps. In the meantime, there's a bunch of other stuff that was outstanding. So we gotta figure this out. Did you lose your job?
Yes, I did, Your Honor, but I just started a new job 2 nights ago.
I don't think I want to make you lose a second job, but where's your new job?
Emo Technologies.
All right.
Yeah, I did have a review advisory rights on my files, so I don't think we need to go over those on the record. Sign it.
Well, of course, these aren't all in the same place. In 251723, you're charged with malicious destruction of property. It's alleged that you injured a car that belonged to Jeffrey Wilkins. That's a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. They also charge you with failing to stop after a collision, which is punishable by up to 90 days in jail and a fine of up to $100. This vehicle is alleged to be stolen. In file 251763, you're charged with retail fraud and retail fraud. In file 251646, you're charged with another retail fraud. I just gave you about 30 days in jail for a bunch of retail frauds. These preceded that. I still haven't figured you out. 1646 alleges that you were in the Walmart store and you stole stuff. You have priors. That's alleged that you took $33.98 and then another $18.97. There's video of these. And then the other retail fraud is Mr. Bush's. Easier, they put these next to each other. I don't think one of these is in here. 1723 we addressed. 1646 we addressed.
Those are both mine.
There's the no. There it is. The file 251763 alleges that you were in the Walmart store way back in 23 and took property, a retail fraud in the second degree. So there's a plea agreement which encompasses all of these files. You're going to plead to file 251646 and pay restitution. That's a second degree. And you're gonna plead in 251763, which is Mr. Harden's file. And Mr. Bush's file is this, gonna plead no contest to malicious destruction of property.
That's correct, Your Honor, for civil liability purposes.
All right. Well, let's talk about that, Ms. Benton. You've signed your advice of rights. You understand you'll be giving up your rights by entering this plea?
Yes, sir.
And you'll be giving up your right to have a trial in that regard. All right, I better get out of ROA here and make some better notes. All right. As I said, these files are spread all over the place. Let's start with the first one. In that file, 1763, Mr. Bush represents you in that case. Were you at the Walmart store on last June 8th? And did you take some property?
Yes, sir.
What did you take?
I don't remember.
Let's take a look. It's hard to keep it all straight.
That's been somewhat a problem. These are put together.
There's a DVD you took. This is multiple dates, June 8th, 78, 87, May 22nd, 84, 43, and 26, 47. Skip scanning. Anyway, do you acknowledge on those dates that you skip scanned some items at the Walmart store?
Yes, sir.
All right, the 1723 is August 4th. Now that's after, was that after you got out of jail?
No.
Before you went to jail?
Yes.
All right, this alleges that you maliciously destroyed a car that belonged to Jeffrey Wilkins. They're going to dismiss fail to stop after collision.
This is the no contest plea?
Yes.
Thank you.
By pleading no contest, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. Do you understand?
Yes, sir.
All right. The affidavit is a little screwy here, but the affidavit says that the caller was at the Dollar General in White Pigeon Jeffrey Wilkins advised he had stopped at Dollar General to pick up some items. He observed the red Buick Encore that his father had reported stolen. So he blocked it in with his Mercedes 300, C300. The expired plate. He went into the store to confront you, who had allegedly stolen the vehicle. She exited the store, got into the vehicle, and backed into his car 3 times. And then saw a child in the backseat of the Buick. So he moved the car, and then you got out. It's expensive to repair a Mercedes. Damage consisted of a broken plastic air vent in the lower front bumper and the parking lots on both sides.
The report does indicate some of the damage
Was previously, yeah.
Thank you.
And he only paid $1,000 for it, so I guess it's an old beat up Mercedes. All right, so accept that plea. That's a strange one. Who was the guy that, well, I don't, it's no contest, so I'll just leave it at that for now. And then the other larceny is 1646. That was at June 19th, June 29th. And they allege that you pushed a shopping cart outside the store and you underswiped some things, put in a beach bag, and it totaled $33.98, $5, and $18.97. Did you push a cart out of the store on that day after underringing some stuff?
I didn't, I mean, they usually always stopped me at the door, so.
Apparently they didn't, and you walked out. They have 11 total incidents with you just at the Walmart store. And this one was that day. I put you in jail the last time because you knew this warrant was out there and you stayed under it. And then all this other stuff percolated out. I gave you 30 days in jail and you lost your job. Now you're out and you have a new job. There's a reason why you keep doing all this stuff. In fact, I thought I'd already barred you from Walmart. I don't think you're even supposed to go in there, but I'll have to look at the timing on all these. I'm going to set this for sentence for the PSI. I talked about this when I talked to you the last time. There's psychological reasons why you're doing this. Although bashing into this guy's car, smashed into Mercedes 3 times probably was expensive. I'm not sure what that was about. They alleged that the car you were in was stolen. It probably wasn't stolen. It was probably taken and then not returned as it was supposed to be. Good morning. Good. I'm gonna try to go about 3 to go to the visitation, but otherwise, all right, thanks. Yep. We try to keep somebody in the building at all times and just wants to check in to see how I'm doing here. Miss Benton, where are you living?
With my boyfriend on River Road.
I'm gonna set this for sentencing for November 17th. 10:30. Does that work for you, Mr. Bush?
I didn't catch the time.
November 17th at 10:30.
That's fine, Your Honor.
I don't know what to do with you, Miss Benton. I've got to check the sequence of all this. And as I said, I just gave you a jail time, which costs you your job.
Your Honor, I'm assuming my files being sent that day as well.
Everything. I forgot to ask you. Yes, Jordan, I'm sorry.
That's it. Thank you. Just wanted to make sure.
Thank you. So I want you to take this out to the counter. And that'll give you information about when to come back. And I'll see you on November 17th with a pre-sentence and try to figure out what the course of action should be.
Thank you.
Thank you, Judge.
All right, friends, it's that time again to say goodbye. But I think we had a pretty good week this week and really enjoyed spending time with you guys. And as always, I keep telling you this, but it's true. You're the reason I get up so early every morning is this is so worth it and so fun. This is the most fun thing I've ever done. So appreciate all of you. We'll be back tomorrow night, 8 p.m. Eastern, 5 p.m. Pacific for game night. I have not announced yet what I'm going to play, but I have an idea. And if I follow through with the idea, it'll be something that we have not done before. So that should be fun. So join me for that. And Monday, 10 a.m. Eastern, 7 a.m. Pacific for the morning show, 45 minutes early for channel members. We're going to expand it just a little bit for the pre-show and see how that goes. So we'll see y'all then. In the meantime, go have yourselves a great weekend. Take care. God bless.